All right, I will call to order the Zoning Board of Appeals meeting for February 8th, 2023. To all persons interested in or affected by the actions of the Zoning Board of Appeals, you are hereby notified pursuant to Section 11, Chapter 40A of the General Laws of the Commonwealth of Massachusetts and all amendments thereto, that a public hearing on the following appeals will be held on Wednesday, February 8th, 2023 at 7 p.m. I will call to order with an introduction of board members. Herb Bodenseek.
I am present.
Paul Pinard.
Present.
Todd Willantis, not present. Mark Hansen.
Present.
Aaron Webb.
Present.
Denise Johnson. Present. And I am Jacob Dewey, chairing the meeting tonight. Notice of recording. Please note that this meeting is recorded and broadcast on Channel 18 and in accordance with MGL Chapter 30A, Section 20. I must inquire whether anyone is taping this meeting, and please make their presence known. Seeing none, we will move on to our first request, which is a time extension request. In appeal number 2021-066, there is a request by Attorney Jennifer E. Carey on behalf of the Manzi Katuitt Trust and Slow Marsh One Nominee Trust for a 6-month extension of time in which to exercise appeal number 2021-066, granted for a variance. The variance was granted in order to allow an adjustment to lot lines between two lots and is currently scheduled to lapse on February 14th, 2023. The subject property is located at 1446 and 1462 Main Street, Katuitt, Mass, as shown on Assessor's Map 017 as parcel 013 and 021. It's located in the Residence FRF zoning district. So sitting on this will be our regular members, Herb Bodenseek, Paul Pinard, Mark Hansen, Aaron Webb, and myself. Is Attorney Carey here? Yes.
Hello. Hi, Jennifer Carey. I'm representing the...
Just press the button on the mic so it turns green.
Better?
Yep.
Jennifer Carey, and I'm representing the Manzi Katuitt Trust and the Slow Marsh One Nominee Trust. Like you said, the variance was granted last year. It's set to expire February 14th, and the land court just hasn't approved it yet. No changes, everything's the same, and they're still just working it through.
Okay, so it's just a land court issue, basically?
That's right.
Okay. Anyone from the board have any questions, comments? Anna, we don't need to open this for public comment? Correct, okay. Does someone want to make a motion?
I'll move to accept or grant the continuance. Okay.
I'll second, Paul.
And so that would be to August 14th, 2023?
Yes.
Okay. All right, so we have a motion to extend the variance for an action date of August 14th, or an exercise date of August 14th, 2023. And we have a second roll call vote. Herb Bodenseek.
In favor.
Paul Pinard.
In favor?
Mark Hansen.
In favor.
Aaron Webb.
In favor.
And I am also in favor. I guess we didn't need to do a roll call vote. We're in person. So you're all set.
Thank you.
Thank you. All right. Moving along, we have minutes. I've got minutes from January 25th, 2023 and July 27th, 2022. Anyone have any questions, comments on the minutes, or a motion to approve?
Motion to approve.
And a second.
Second.
All those in favor?
Aye.
I'm in favor. Is that for both? Right?
That's for both,
Okay.
yeah.
In favor.
Any opposed? Abstentions? None. So the minutes are approved. Moving on to old business. Appeal number 2022-021. Louis Vuelamir has filed an appeal for an administrative official's decision in accordance with Section 240-88 appeals. The building commissioner issued a notice of zoning violation in order to cease and desist on March 3rd, 2022, which stated that the total number of dwelling units are 4, 3 units in the main dwelling and 1 in the detached barn/workshop, are a zoning violation under Chapter 240-11A1 in the RF2 Residence F2 zoning district. The subject property is located at 4380 Main Street, Barnstable, Mass, as shown on Assessor's Map 351 as parcel 042. It's located in the Residence F2 RF2 zoning district. This is continued from December 7th, 2022. The members assigned were myself, Herb Bodenseek, Mark Hansen, Paul Pinard, and Aaron Webb.
Yes, good evening. Chuck Sabat representing Mr. Vulamir in this matter, and you were very gracious previously in December in granting us a continuance to allow us an opportunity to meet with the building commissioner, Mr. Florence, to determine whether or not we might find an alternative pathway to establish a legal use of these otherwise allegedly offending units. We did meet with Mr. Florence, and we talked about a potential 40B application, and we then met with Peter Freeman, whom I think the board knows is a specialist in 40Bs, and we've been looking at some options in terms of multifamily units and some sort of zoning relief to achieve that. And the bottom line is that I think we've come back to wanting ultimately to file next an application for a special permit for an accessory dwelling unit. I just spoke briefly with the building commissioner about that. So the time that you granted us was used effectively to explore these various options, and I would be asking tonight if you would be gracious enough to give us another continuance of this matter, and our intention is to in all likelihood, file an application for a special permit for an accessory dwelling unit, because I think we're going to have to vary a little bit from what the otherwise permissible use of an ADU would be. So that's going to require some time to develop the plan. You have to have a plan that shows elevations, floor plans, and so on, and a little bit of time to do the application. So it'll either be filed by myself or by Peter Freeman on behalf of Mr. Vulamir. So I would be requesting an extension if the board is willing to grant that to us for a period of at least 2 months, maybe into April. So that will give us an opportunity to get that application in.
All right, does anyone from the board have any questions, concerns?
Is that enough time? Feel that's enough time, at least to get it
Far out
in?
as I see is March 22nd. I don't know what our April meeting dates are.
I don't know, we may need more, and I'm always in favor of buying as much time as I can for anything, but
Is there site engineering required for this?
I don't know if it's an engineered plan, but it's a pre-existing, these are pre-existing structures. These would be internal renovations, removal of 2 units, and 2 kitchens. So I think we would only need floor plans. I'm not even sure we would need elevations. It's not new construction.
Yeah, the ADU stuff's pretty minimal on some of that stuff.
Okay. Just
Special
checking,
site plan.
because it can go far out, obviously, with that. That's fine.
The April meetings are April 12th and April 26th.
All right, I'll take April 12th, if that's available.
All
I
right.
have something on the 26th.
So I'll make a motion to continue appeal number 2022-021 to April 12th, 2023.
Second. Paul?
All right, all those in favor?
Aye.
Opposed? Abstentions? None? All right.
Thank you
Attorney
very
Sabat,
much.
you're all set. Thank
Thank
you.
you.
All right, moving along quickly. In appeal number 2022-054, Kevin Y. Villasante and Corey L. Villasante have applied for a special permit pursuant to 240-471B for family apartments. The applicants are seeking to demolish an existing 1,384 square foot accessory structure and construct a new 1,384 square foot detached family apartment. The subject property is addressed as 358 Flint Street, Marston's Mills, Massachusetts, as shown on Assessor's Map 101 as parcel 121. It's located in the Residence FRF zoning district. This is continued from January 11th, 2023, and we have a letter to withdraw from Attorney Corain. Does anyone have any questions, comments? All right, I'll make a motion to accept the withdrawal of appeal number 2022-054 without prejudice.
I'll second that.
All those in favor?
Aye.
Opposed? Abstained? All right, so that is withdrawn. Moving on to new business. And just because there's a bunch of people here, just so everyone's aware, appeal number 2023-003 is going to be continued. It's the Hillary M. Stone for 94 Indian Trail. So our first item, a new business, appeal number 2022-055. John E. Saluzzi, trustee of Woods Beach Leaf Island Trust, has filed an appeal of an administrative official's decision in accordance with MGL 40A Section 15 as Barnstable zoning ordinance sections 240-88, 240-90, and 240-91 appeals. The petitioner seeks to overturn the building permit denial letter of the building commissioner dated November 4th, 2022. In the building permit denial letter, the building commissioner stated the petitioner did not demonstrate conformance with the zoning ordinance section 240-11, and that the lot does not have the required land area, and that the application lacked evidence that would show that it benefits from the single lot exemption under MGL Chapter 40A, Section 6. The subject property is located at 149 Beachleaf Island Road, Centerville, Massachusetts, as shown on Assessor's Map 187 as parcel 063-005. It's located in the Residence D1, RD1 zoning district. So sitting on this tonight will be our regular members, Herb Odenseek, Paul Pinard, Mark Hanson, Aaron Webb, and myself.
Mr. Chairman, before we start, if I could just disclose petitioner's mother is a next-door neighbor. If anybody takes issue, I'm happy to defer to another member.
Do you want to defer to another member? We have another member here, so maybe it makes sense to defer. Denise, are you okay to sit on this? All right, so we'll defer to Denise on this. All right, Attorney Johnson.
Good evening, Mr. Chairman and members of the board. Jeffrey Johnson on behalf of John Saluzzi. A little history, and it's a long history, but I'll try to make it short. We were here in 2017 trying to accomplish the buildability of this lot. And at that time, after several hearings and trips to the land court to discover further evidence on some of the shape and size of an abutting lot, we ultimately lost and appealed that to the land court, and that land court appeal is still pending. As part of that process, the judge in that case asked us if we would be willing to come back to the building commissioner on a fresh theory of buildability. She felt that it would be best decided by the building commissioner as to whether he agreed with our fresh theory. The original denial was not by Mr. Florence, but by a temporary interim building commissioner. And so that's procedurally where we are with regard to the land court. So submitted some materials to Mr. Florence and did some follow-up with Mr. Florence, and if any of you have read his denial letter, he wasn't pleased with the depth of the materials we could give him as to several issues, and I'm willing to address those. I think his letter uses gaps in information and questions about beneficiaries. In terms of gaps in information, we're talking about corporations and trusts that were in existence in the 80s and early 90s. The history of this subdivision, it was developed by the Sylvia brothers, who had some financing with Cape Cod Bank and Trust, and to develop the land, and they checkerboarded these lots between two corporations, and then they gave, in essence, a deed in lieu to some limited partnerships controlled by Cape Cod Bank and Trust. And then Cape Cod Bank and Trust sold these lots out to Mr. Brian Dacey as trustee of 3 different trusts. Now, the issue arose as to, Mr. Florence was inquiring as to whether the Sylvias had anything to do with these trusts. I've provided in the file and was provided to Mr. Florence an affidavit from Brian Dacey that identified who he believed the trust's beneficiaries to be. They certainly were not the Sylvia brothers. In discussing what evidence we might be able to produce as to who the beneficiaries of these trusts were, those records are so old, no one has them. Mr. Dacey doesn't have them. I inquired of his attorney at the time, Martin O'Malley. He doesn't have them. I inquired of Donald Henderson, who represented CCB&T at the time. And if you know anything about nominee trusts, you know that they're a secret off-the-record document. But whenever you borrow from a recognized lending institution, they want to see those documents. Well, those loans have long since been paid off, and Mr. Henderson, all of his files are gone. So all we really have as to who the beneficiaries of that trust is Mr. Dacey's affidavit that he was careful to separate them. There's been a suggestion made in the past that maybe copies of his tax returns from that far back would help elucidate who the beneficiaries were, but that isn't the way nominee trusts work. They don't file a separate tax return. The income flows to the beneficiaries, and if the beneficiaries are related, it all gets put into one tax return. It's an issue of control. In a nominee trust, the beneficiaries direct the trustee as to what they can do. And all of these lots, if you've had a chance to look at my memorandum, it has some of the histories. These lots have maintained their checkerboarding history throughout, except for one small period of time, which Mr. Reed points to in his memo to you, between 1994 and 1995, when Marjorie Woods owned both 520 South Main Street and this Lot 7 on the land court plan. I would suggest to you that although there was a period of time of commonality of ownership of those two properties, that if you read the language of your bylaw, they don't merge. And I'd be willing to go through that with you. If you look at the single lot exception to your bylaw, and I set it out in my memo, and I've tried to highlight sections of it that are pertinent, it talks about a lot not held in common ownership with any abutting lots. So again, we have the Sylvia brothers who put them into separate corporations. Then we had CCB&T who put them into separate limited partnerships, and then Mr. Dacey who put them into separate nominee trusts. But the real question is not whether they later came back into common ownership. If you look at the final clause in Section A of 24091, it says, was separately owned at the time of every zoning change which made it non-conforming. In the simple language there is, you have to look at who owned it on the date of each change. And there were two changes in the history of this section of Centerville that are pertinent. The first one is the last day of February, first day of March in 1985. The Sylvia brothers checkerboarded it before that change. And the next change wasn't until November of 2000, when we went from 1 acre to 2 acre. And in November of 2000, these properties weren't commonly held. By November of 2000, Marjorie Wood's daughters owned this lot, and she owned the house. And I know that there's been a suggestion that that might not be a valid checkerboarding scheme, and that there's suggestions of control, but that isn't the case. The mother could sell her house without the daughter's permission, and the daughters could sell this lot without her permission. And I believe that that's been upheld. I don't want to spend too much time on this. I've put a lot of time into the memo. I think that this lot could be argued to be separately buildable under 4 different sections. The single lot exception. Then my next theory is that under the common lot exception, if you separate lots that are commonly joined within 5 years of the change, well, all these lots were separated out prior to the change in zoning, and even if you take the position that they were later joined, I would suggest that the intent of this section of the bylaw would be to allow you to separate them out again in 5 years. I know Mr. Florence doesn't agree with that, but it's an argument I've made and I'd like to put before you. The third reason I think that these lot has not merged with 520 South Main Street, which was essentially the basis of the prior case, is that under your 2000 change in the zoning, you were very clear, the town of Barnstable was very clear that any acre lots that were improved had vested status. Now that word vested means something. And the merger clause in your bylaw specifically says that except as herein elsewhere provided. So 520 South Main Street is a full acre lot. At one time, 5 years ago, we thought that it was separated by a way, but it's only separated by an easement. We've determined that. But it's a full acre, and if you add a piece of property to it, you destroy the vesting, and that's contrary to your bylaw. And your bylaw at 240 Section 90 says the overall intent of your bylaw here is to protect the rights and to protect the value of property owned, okay? The final argument that I've made is that I believe that you can make an argument that this lot enjoys what we call commonly plan protection. When a subdivision plan is endorsed, you have 8 years to sell off the lots into separate ownership or to build upon them. Now, this particular lot has been conveyed no less than 3 times within that 8-year period. The other thing that I would like to point out to the board, and again, I don't want to take too much of your time, is that all the other lots, and I know that that's not necessarily a criteria, but I'd like you to just think about this. Every other lot on this street benefited from the argument that the checkerboarding scheme by the Sylvia brothers worked, and not a single lot on this street pulled a building permit within the plan freeze protection period. I produced just a quick let's call it a flow chart of who owns what on what particular dates, and I'd like to present one to each of you so you can see who owned what on each date. Rather than belabor it much further, this chart shows that on July 30th, 1984, that's when the plan was approved and signed. At that time, the Sylvia brothers, Sylvia and Sylvia Associates, Inc. owned all the lots except for 520 South Main Street, which was owned by David and Marjorie Woods. The date of the zoning change, Sylvia and Sylvia Associates owned the locus that we're talking about, and Beechleaf Island, Inc. And Beechleaf Island, Inc. owned the lots on either side of it, and David and Marjorie Woods owned 520 South Main Street. There are no other properties that abut this property. There is one property that abuts at a point, but that doesn't count. The next event is the 5 years in which you had to checkerboard them, well, they were already checkerboarded. That's 3/1 of 1990. On 7/30 of 1992, which is 8 years after the plan was signed, the properties were owned by Thornberry Lane Nominee Trust, Scudder Bay Nominee Trust, Beechleaf Nominee Trust, and David and Marjorie Woods. Those are the Dacey ownerships. So I say it was, again, deeded out within the plan freeze period. Then in 1992, Mr. David Woods solely, not with his wife, bought our Lot 7. And at that time, Scudder Bay nominee and Beechleaf nominee and the Woods owned the other two properties. Unfortunately, David passed away in January of 1994. His estate was probated, and for that short period of time between 1994 and 1995, his wife owned the house at 520 South Main Street and this lot. But again, the way your bylaw reads, it's commonality of ownership, in my opinion, in my argument, on the date of a change. So there was no change. It had already been checkerboarded out. Then in 1996, the daughters get the lot. I list the owners of the abutting properties. And most recently in August, Mr. Saluzzi bought our lot, and the abutters are listed there. If any of you have any questions, I'd be happy to answer them.
Thank you, Attorney Johnson. Anyone from the board have questions for the applicant? Herb? Denise? Aaron? No? So what we're being asked here is to overturn the building commissioner's denial, which needs a vote of 4 to 1.
You know, I don't feel comfortable with the legal arguments, quite frankly. I'm not a lawyer. And they're made well and in depth. And I would feel more comfortable if we had the opinion of our attorney with respect to this.
Okay, well, let's open up for public comment first, so we can hear from the public, and we can hear from another attorney.
Thank you.
All right, so I'll open public comment.
Good evening, Mr. Chairman, ladies and gentlemen. I'm Attorney David Reed, and I represent 5 of the households that circle around this piece of property. The Cirillos of 153 Beach Leaf Island Road, who are abutters. The Gerlovins of 518 South Main Street, which I believe is the property that Mr. Johnson referred to as it abuts only at a single point. It's technically an abutter, but not really in common ownership. The Rigobans of 147 Beechleaf Island Road, who are abutters. The Robinsons of 155 Beechleaf Island, who are removed by one lot. And similarly, the Delaney's of 143 Beechleaf Island Road, who are also removed by one lot. So they're neighbors, but not direct abutters. You should have 2 letters from me sent all yesterday. I apologize for the lateness of those, but some of the materials on which Mr. Johnson relies tonight didn't come into you until January 30th. So we've had only that much time to respond to those and to get a response in to you. As I've indicated in my letter to you, I don't believe that it matters whether any of the initial grandfathering provisions of your ordinance, which Mr. Johnson referred to, would have provided protection to this lot because of the subsequent common ownership with the Woods family. I believe his theory is not supported, that your definition of merger in 140-91E, I believe, is limited to the date of the transition from one zoning regulation to another. Subsequent common ownership also destroys the protections. The protections provided in the ordinance are for new lots when they are created and for the period of time following creation when they are developed and parceled out and sold or built upon. The fact remains, however, that that zoning protection, that grandfathered protection, can be lost if one chooses to acquire adjoining land and one or both of those parcels are non-conforming. The law of merger is not dependent upon the owner's intentions. It is by operation of law. Once a non-conforming lot comes into common ownership with an adjoining parcel, the two lots must be treated as one, at least to the extent necessary to cure or minimize any zoning non-compliance. That doesn't matter what the owner's intention was. That is a fact, and that is the legal requirement following such a common ownership period. And at the very least, from 1993 to 1994, 94 to 95, Marjorie Woods owned both 520 South Main Street and this parcel 7, or lot 7, in her singular sole ownership. And they are abutting each other by some 280-plus feet of common boundary line between the two lots. I can address each of the provisions that Mr. Johnson referred to as to why I don't believe that those initial grandfathering protections apply. Initially, as to Section 240-91A, the single lot protection, which appears to be the only one on which Mr. Florence was concentrating, provides that the lots have been separated from any common ownership at the time the zoning changes. And the zoning change was on March 1st of 1985. As Mr. Johnson indicated, in 1984, when the lots were developed by subdivision, they were conforming. And in late 1984, Sylvia and Sylvia Associates conveyed every other lot to the Beach Leaf Island Incorporated. However, if you look at that deed, it reads Sylvia and Sylvia Associates Incorporated of 619 Main Street, Centerville, conveys to Beach Leaf Island Incorporated of 619 Main Street, Centerville, and proceeds to convey every other lot in what is classically referred to as a checkerboarding scheme. If you look at the records of the Department of Corporations, those two corporations are identical. The sole incorporators, directors, and officers of both of those corporations are Ronald and Floyd Sylvia at the time of these transactions. There was no separation of common control. There was only a paper transaction that gave the appearance of separation. So I do not believe that the single lot protection protects those at all right from the beginning. In addition, I disagree that the change in 2000 is also exempt from its regulation because at that time the Woods family owned both 520 South Main Street and Lot 7. As for the multi-lot protection under subparagraph B, which gives protection for 5 years from the zoning change, which would be until March 1st, 1990, again, we have the same question of whether or not the Sylvia and Sylvia transaction was an effective checkerboarding or an effective conveyance of every other lot. I suggested it was not, and in fact, Beach Leaf Island Incorporated did not convey away Lot 7 until the following year, after the 5-year protection expired. As for the subdivision freeze, the so-called subdivision freeze, the 8-year protection under subparagraph E, it says that the protection is only if the lot has been conveyed into separate ownership from any adjoining lot within that 8-year period. The 8 years expired on July 30th, 1992. At that time, the property was owned, this lot was owned by Mr. Brian Dacey, trustee of the Thornbury Lane Nominee Trust. And you will recall from Mr. Florence's letter that that is the very trust about which he inquired and required additional information to know who that trust was. And as Mr. Johnson obviously correctly indicated, if you don't know, a nominee trust means that the trustee is just a figurehead. The real owners and the real control of the property remains the beneficiaries. So until you know who those beneficiaries are, you don't know who's in control of the property. And the merger provision by law and in your ordinance says that lots that are either in common ownership or in common control by the same parties are deemed merged. I suggest that the applicant has not responded effectively, and maybe they can't, maybe the information isn't available, but for whatever reason, they have not and cannot respond to Mr. Florence's inquiry to negate that apparent issue of whether or not there is common ownership and control under the Dacey ownerships. Now, as to the letters that I sent in to you, the first one raises what I think is a significant and unusual procedural issue. The law requires that for one to appeal a building commissioner's decision, you must do so within 30 days. And under Section 48, Chapter 48, Section 15, that notice of appeal must, among other things, specify in the notice the grounds for the appeal. And that statement of grounds for the appeal must be filed not only with the town clerk and with your board, but also with the building commissioner, so that he can respond to it. He is actually directed to respond by providing all of his information to you. That was not done. If you look at the application before you, it says nothing about why the applicant is appealing, nothing about why he believes Mr. Florence's decision was wrong. It offers no additional evidence over what he has already submitted to the building commissioner, and indicates absolutely nothing about why he's appealing to you, other than the fact that he disagrees with the decision. It's not until January 30th of this year, almost 2 months after the deadline for finding the appeal, that the real memoranda of reasons from Mr. Johnson comes to you. And at that time, he presented a lengthy, scholarly, and detailed presentation to you of the title to these properties and the reasons why he believes it's exempt and entitled to protection. While I disagree with his conclusions, it is a thorough presentation to you at that time. But that's not what the law requires. It requires that be presented within 30 days of the decision made by the building commissioner, not 2 months. The second letter I sent in to you gets to the merits of the case. And aside from the issues of the interpretation of your ordinance, I suggest to you that there are a number of key dates that have already been mentioned that are important to the ultimate decision in this case. The fact is that in 1992, Mr. David Woods, who was an owner of the house and property adjoining at 520 South Main Street, acquired this Lot 7. As Mr. Johnson indicated, he passed away, and his wife Marjorie became the sole owner of those 2 lots from 1994 to 1995, after which she conveyed a 1/2 interest to her children, and a year later conveyed the other 1/2 interest to her children. And they continued to own it for a total, for the Woods family, of 22 years. In 2014, Mrs. Woods, Marjorie Woods, conveyed away the 520 South Main Street property. And the following year, in 2015, the children of Mr. and Mrs. Woods, who owned Lot 7, applied to you for a variance to, quote, unmerge Lot 7 from their former house lot on 520. They acknowledged that it had merged. They asked you for a variance to relieve them of that effect. When the hearing came around in 2015, September, I believe, they ultimately withdrew their application, so no decision was made. And then 2 years later, Mr. Saluzzi came forward asking for a building permit and appealing Mr. Roma's denial to you. In 2017, after 2 or 3 hearings, you finally denied that application and upheld his decision and ruled principally that by virtue of the common ownership by the Woods family, and particularly by Marjorie Woods, that destroyed the grandfather status, that it merged the 2 lots, and that it could not thereafter be separated into individual lot ownerships, because to do so would create a nonconformity at that lot, which was partially, if not completely, absolved by the merger of the 2 properties. As I indicated, merger happens automatically. It doesn't matter what the intentions of the parties were. So whether the Woods family intended Lot 7 to be just an addition to their own lot as a protection or buffer for them, or whether the merger was a mistake that they didn't count for, it doesn't change the result. The fact is, they merged in 1994, at least by then, when Marjorie Woods became the sole owner of the two properties. The zoning has changed twice since this property was created as a separate lot in 1984. In 1985, it was increased to 1 acre zoning, and in 2000, it was increased to 2 acre zoning for the Resource Protection Overlay District. This lot has been non-conforming for 30 years before anybody made an effort to develop this lot. It was in common ownership of the Woods family for 22 years without any effort to develop it. After Mrs. Woods conveyed Lot 7 to her children, they owned it for another 20 years before they made any effort to develop this property. That's when they came before you to ask for a variance in order to unmerge the lots. It wasn't buildable then. It's not buildable now. We would ask you to uphold Mr. Florence's decision, to affirm your previous decision, and to decide that this is simply not a buildable lot at this time. Thank you, ladies and gentlemen.
Thank you, Attorney Reed. Do you have any other members of the public to speak? Go ahead, come up to the podium and just announce your name and address.
Good evening. My name is Christopher Lothrop. I'm the owner of 520 South Main Street, one of the properties in question here. I purchased the property in January of 2021. In the spirit of transparency, I was told at the time of these ongoing legal issues with this property. At the time, it only went back to 2015. Now, listening to the attorneys, it's been going on much longer than that. What I was told at the time when I purchased the property was that, look, the law of the land here in Barnstable is that you have to have a minimum of 1 acre of property. And the lot sits there at 0.65 acres. It's not even close. So I went so far, even before purchasing the property, of talking to the building inspector. Obviously, he was in no position to give me any insurances, but made it very clear that, Chris, all I can tell you is that this is the law. This is the zoning ordinance that exists, that you have to have an acre. But this keeps going on and going on and going on, and you know, I just find myself, as the owner of the property for over 2 years now, just always in a position where I seem to be looking over my shoulder because there's another application, another thing going on. So I was told that, look, this building application was rejected. It came before this board and the zoning variance board upheld the rejection, but now there's another one, and here we are again today. So I at the time, when this all started happening most recently, I wasn't represented by counsel. And so I took it upon myself to call the owners of the property at that time and say, look, I own the old family homestead, the Woods family homestead at 520 South Main Street. There's this lot that's sitting there that's not a buildable lot according to zoning laws, but I'd be willing to purchase it from you. At which time I was told, well, that's very interesting. Unfortunately, the property is currently under contract, so I can't really do anything about that, but if ever that contract comes to an end, you'll be the first person I call. Okay. So, again, some time goes on, I don't get a call, and I start thinking that maybe I do need legal representation. So I tried to secure legal representation here on the Cape. Talked to 12 different firms here on the Cape. Either they refused, they wouldn't return my call, or they pleaded some type of conflict of interest. I mean, the home that I live in is 150 years old, so I can understand why there's a lot of history here. And, but I went off Cape, secured an attorney, out of New Bedford, because I couldn't find anyone here that would represent me. So I am represented today by Attorney Feingold out of New Bedford. He couldn't be here tonight because he's in trial. But all of a sudden, he came on the scene, and my objectives changed. I don't want to see the property developed. I have no interest in developing the property. It sits right there. It's a beautiful piece of property. It's undersized. It's unbuildable, according to the bylaws here. But between my attorney and the owner's attorney, they got together and we made an offer, either to buy out the existing contract or to buy the property. And again, with absolutely no interest at all about coming back here at some point and asking for a variance, it was just, I looked at it as an opportunity to increase my property, which is about an acre and a half, 1.3 acres, and I'd add another 6.65. It seemed like a win-win for everybody. Buy out the contract, I buy the property, this problem goes away, the abutters are all happy, I'm happy. It didn't happen, and we find ourselves here tonight. I don't know, it just doesn't seem right that we keep fussing over this piece of property when it's not buildable. And, money keeps getting exchanged and money keeps going on and on and on because we seem to be unable to take no for an answer. And so, like I said, in the spirit of just trying to make a win-win for all parties concerned, I just wanted to state my case that as the owner of 520, I love the property and I'm very happy to be here. I just don't understand why this keeps happening. So I thank you for your time.
Thank you. Any other members of the public want to speak? Commissioner Florence is here if anyone has questions, or Commissioner Florence, do you want to say anything?
Good evening, Mr. Chairman, members of the Zoning Board of Appeals. My name is Brian Florence. For the record, I'm your building commissioner. This is a simple case for me. This is a case of the missing documents, quite simply. I never reached the technical merits that you've heard this evening of the case from Attorneys Johnson and Reed, because my review of the corporate structures with the Secretary of State caused me to seek out the documents, the trust documents, more specifically the scheduled beneficiaries that you've heard talked about this evening. As Attorney Johnson said, this is an issue of control, and in my review, I have to understand whether or not lots have merged, and the only way I can do that is find out who controlled them. The affidavit identifies, so Mr. Johnson talked about an affidavit this evening, so when I asked for the scheduled beneficiaries, I got an affidavit instead, and the affidavit discussed who Mr. Dacey believed were the beneficiaries, but there's no definitive proof, because as you heard this evening, the documents were missing. My role in these determinations is established in Mass General Law 40A, Section 6, where it says, the inspector of buildings, building commissioner or local inspector, or if there are none in the town, the Board of Selectmen or person, board designated by local ordinance or bylaw, shall be charged with the enforcement of the zoning ordinance or bylaw and shall withhold a permit for construction, alteration, or moving of any building or structure if the building or structure is constructed, altered, or moved, and it would be in violation of the zoning ordinance. So the shall in that section of the law is an imperative. It doesn't give me any discretion. It says I shall not issue a permit. So without the ability to follow the chain of ownership, I cannot say definitively if control was retained throughout the zoning changes, and therefore I didn't bother to look at the merits of the case. The door was effectively closed to me once I couldn't get past control. Had I done that, you would have heard from me all of the same discussions you've heard from Attorney Reed and from Attorney Johnson, but they would have been from my perspective. So I could not establish control, and I don't think the board here can either. So if you have any questions of me, I'd be happy to answer them.
Mr. Commissioner, one point was raised by, I believe, Attorney Johnson with respect to, Attorney Reed, with respect to 30 days. The appeal has to be made within 30 days, and the basis of the appeal must be stated. Did you look at that in terms of the appeal?
Those appeals don't come to me. I'm supposed to be served with documents, but I didn't get served, and those were given to the Planning and Development Office.
Denial letter was dated November 4th, 2022.
Yep.
Maybe Attorney McLaughlin can help answer that. He's
Well,
here
the
as well.
denial letter was based on, so when we get a building permit application in our office, it comes through the OpenGov permitting software.
Right.
So that's where the review takes place, at the computer and in the resources I have available to me. And so when I made a determination that I couldn't determine who had control, or a complete determination of control, I made the determination in that software system and that's where they were informed of my denial. Does that answer that question okay?
Yeah, I think the question was, is it required that you receive the appeal within 30 days?
It is, yes.
Okay.
I have a question
But
also.
but my question was it an appropriate appeal? Technically, it's a technical question, but is it an appropriate appeal? Attorney Reed said it wasn't.
It's a good question. I will step away. I'll leave that for you
I
folks to
understand. I
determine.
understand.
Are there any other questions for me?
But that's my question.
Yeah, hi, what I read on the surface going into it was that it was an incomplete application, correct? They didn't give a reason
Right.
why they're not even appealing our decision. This is just a new appeal, correct? So they didn't give a reason, and I guess until recently, they did not. And then the other issue is the land court decision. I don't know if this is really germane to what you're talking about, but the land court decision didn't overturn our 2017 decision either. It's simply, go ahead, take a shot.
Those are matters of law. I'll leave it to the lawyers to explain,
Yeah,
but it's very.
I read that and I interpreted it.
Yeah, it was
from
basically.
Some other lawyer reading.
It wasn't remanded back here, but they were asked to come back here. So they can explain that further, but, and maybe Attorney McLaughlin would be happy to do that, but I don't have any response to that one. Anything else? Yes?
I have a quick question. So in terms of determining, rightful ownership or beneficiaries of such trusts, if there is no documentation to support finding an answer, what are we to do at that point? Again, is that a land court? Does that get worked out in land court? Or, I understand you weren't provided with, or you were unable to find who the beneficiaries were of the Thornberry Lane, trustee. But at that point, I'm just confused as what happens? This land just sits sort of out there that's it, just sits there forever.
Member Webb, that's where you guys come in.
Yeah, no, I understand that. It was, in my opinion, and this isn't necessarily directed to you, but my opinion is that the subdivision was built out at one point by Sylvia and Sylvia Associates. Lots were established as such, right? Then there's this long list of ownership, trustee, I don't want to say blah, 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 but, mixing and matching of who owns properties. And then it comes down to Mr. Chiluzzi purchasing the lot under the assumption that it's a buildable, he can put a house on it, and now here we are.
Well, I don't think we can say that he made the assumption it was buildable. He was before us 5 years ago.
Yeah, well, again, I wasn't.
Which was denied, and he didn't own a lot at the time.
Yeah, I don't know. I'm just at a lot. I don't get it. I don't know what happens to the lot at this point. It just sits
It
out
can be
there.
an unbuildable lot. Someone can own an unbuildable lot.
Yeah, I understand that. But when it was established to be buildable in a subdivision of other homes, correct? Wasn't that the intent or the idea that
don't think we
when
can
Sylvia and
speak to
Sylvia bought the lot?
If I may, Mr. Chairman,
Yeah, go ahead.
zoning changes, and you have opportunity for a period of time after each zoning change to separate those lots out. Otherwise, they merge. And so This is a case of whether or not the lot's merged with another lot. And so it's not a dead lot. It may belong to somebody else, and there may be an ownership issue, but zoning was enacted for a reason, and it's established that way so that if a lot merges, it merges. And so I don't have a way of telling because the documents weren't provided, but it's the burden of the proof belongs to the property owners to demonstrate that they have the right to build, not up to us as the building official and zoning board of appeals to make their case for them. Hope that helps.
It does, thanks.
Anything else,
Does
Mr.
anyone still
Chairman?
have any more questions for Commissioner Florence? Okay, thank you.
Thank you.
Do we want to have questions for Attorney McLaughlin? Attorney McLaughlin, are you willing to answer some questions? And then maybe we let Attorney Johnson.
Good evening, folks. Attorney Charles McLaughlin for the town. And I will give you a little bit more of the background on how the case came back to you. Excuse me, ma'am, getting over a cold here.
Keep it over there.
The matter was pending before the court, and we had several status conferences. And I said, what was the appeal from your affirmation of Paul Roma's denial of the building permit? It came to you, you affirmed the building inspector, and it was appealed up to the land court. We had several conferences up there, and there were various issues that needed some clarification and questions that devolved perhaps into engineering, trying to identify where some land was and where some wasn't. And this was a very active and engaged judge on the matter and very experienced. And at the end of the day, a couple of years into the litigation, the plaintiff, as indicated through counsel, had said that their theory of the case had changed given some of the additional work that had been done on the ground in the meantime, and also apparently further evaluation of some of the theories under which relief might be granted to indicate, in their opinion, that the lot was not merged and therefore potentially buildable. That immediately brought on a discussion of concern to me and also with the court, and I think Attorney Johnson agreed that what was pending in the litigation there was a challenge to ultimately your decision affirming Paul Roma, the then interim building inspector's denial on a specific and detailed set of facts that were presented both to Paul Roma and then to you folks. And we had a position taken by the plaintiff that the theory under which relief might be granted had not been presented to either Paul Roma or to you folks on appeal. And that left the court in a bit of a quandary as to what to do. And the decision was made by the court that, and with I think everyone's assent certainly, that it would probably best to remand rather than be forced all of us to try a case that was no longer relevant and that the plaintiff had expressly abandoned their theory on. The thought was, well, all right, if you've got a new theory, rather than go through this process, get a whole new judge, new filing, and so forth, depending on who loses at the local level, the thought was, let's get this remanded back to the local board and actually to the commissioner, ultimately remanded back to the town. The court decided that she would retain the case, so-called retain jurisdiction over the case, so that we wouldn't have to start on appeal from scratch. This judge would remain assigned to it, and if there were indeed an appeal back up from the proceeding we're now in, that we could at least do so somewhat efficiently given the amount of time that the court had spent on the matter. So at any rate, the matter is now back before you. It was back before Commissioner Florence on some different theories of analysis than what had been presented previously. We worked with Commissioner Florence, and I think from our perspective, please do keep in mind, you're probably hearing more about nominee trusts and the like than you ever wanted to, but nominee trust, the trustee, the named trustee, holds just the raw legal title and nothing else. All the control, as Mr. Johnson pointed out, and Mr. Reed, all the control in this situation with nominee trust resides in the beneficiaries of that trust. And it therefore begs the question, particularly given the question of either outright ownership or control, whether or not, with regard to these nominee trusts, there were common ownership and actually common control, because if it's Charlie McLaughlin trustee and two of you folks as the beneficiaries on Trust 1 and Trust 2 and Trust 3 and Trust 4, the only thing being different is the name of the nominee trust, but control effectively in two of you board members in that example remains identical. And we're bumping into this more and more, I might add, just parenthetically, with the proliferation of limited liability corporations and so forth. It's the flavor of the day, if you will, in estate planning and real estate planning to break these projects down into numerous LLCs or nominee trusts, which are somewhat going out of favor, I think, at this point. But we're dealing here with the facts that the key mechanisms for ownership here were the nominee trusts, and we have no information as to, despite, I think, the best efforts of everyone involved from the petitioner's standpoint, to identify what those were. Those records apparently, for whatever reason, don't exist. And the question then before you, before the commissioner, was, does he have enough information from the petitioner whose burden, the property owner whose burden it is to demonstrate that there was no common ownership? The commissioner concluded, no, those questions have not been answered to my satisfaction, i.e., the property owner's burden has not been met, and therefore, at the end of the day, he decided to, on that basis alone, to, as he had indicated, to deny it. And the question before you is whether or not you have reason to affirm his decision based on the facts before you and based on the conclusions, the legal conclusions that he drew that you're being asked to affirm or being challenged by the petitioner. So.
Thank you, Attorney McLaughlin. Do you have specific questions?
I do have a question. Attorney Reed brought up the point, in fact, I think he said his major point, that the appeal was not made, it was not an appropriate appeal or didn't qualify as an appeal within 30 days.
It's excuse me, a very interesting point. That is one I'm going to leave to the land court to decide. This was on remand and did not specifically indicate in remand that a new application versus a new analysis. And we're going to have to get clarity. I'm not going to offer an opinion on that. Mr. Reed is correct that absolutely, if this were coming in the door fresh and you had a 31-day window between the denial and the application, it would be jurisdictional. No further action could be taken, and the appeal would be dead. This is in a remand context, we're going to, if this goes further, we'd have to get a judge's ruling on that. I'm not going to weigh in on it right now.
Okay, thank you. One more, Mr. Chairman. The burden of proof, who has the burden of proof of common ownership or common control?
The property owner has the burden of proof to show that there was not common ownership so as to cause a merger.
Any other board members have questions? Go ahead.
I don't know if it's for our attorney, but my question is, why wasn't this resolved if the smaller property was sold in the last few years? Wouldn't it come up during the process of the sale, whether or not it was buildable?
I was not involved in those transactions.
I'm not saying-
No, I understand that.
Asking
Some people acquire unbuildable property for a variety of reasons, including view shed, and it happens quite regularly, particularly with some of these older so-called unbuildable lots. So I can't weigh in more than that to understand what advice was out there, what the purpose of the acquisition might be, et cetera. So, and I don't, no matter what happened in that scenario, I don't think it directly affects the status of the matter pending either here or perhaps at land court, so.
Aaron, Herb, or did he say more? Go
I have
ahead.
a quick question. So in 1984, when the plan was approved and signed, Sylvia and Sylvia Associates, plan was approved, what was going on with the zoning at that time? Would this have been a buildable lot on 1984? Could they have, Lot 7, clearly defined in this piece of paper that was provided by Attorney Johnson? Could somebody have put up a house at that time?
I'd want to look at it more closely. The question that we've been focusing on all along is post that zoning change, what was the effect of it? I believe, perhaps Jeff may want to respond more directly.
Would it be
to your
considered to
question.
be a non-conforming, pre-existing lot? Again, I mean, there's acre, there are lots in the town of Barnstable that are 1 acre that are pre-existing, non-conforming to the zoning change that are buildable. I'm naive in that.
The point that you're raising is well taken, and that is precisely the really fact-intensive examination that we're making on a pretty regular basis with so much of the property in town being built out and the people searching around for quote-unquote non-conforming undersized lots and the like. And in every instance, we have, not every instance, but in a lot of these examples, we find ourselves digging deeply into the back history of it, and that is exactly what Commissioner Florence was doing in this case. Again, we have not focused, I think everyone agrees that the change to 1 acre zoning is a seminal point in this, and certainly the 2000 change to 2 acre zoning is seminal. How it affects these lots is something that would probably be relevant if we ever get to those merits, but we procedurally are unable to get past, from the commissioner's standpoint, unable to get to that analysis because we don't know what the beneficial interests were and whether they're identical or not identical, and the legal consequences that flow from either of those answers. So I'd rather not speculate at length right now, at least on the 84-85 scenario. My impression, and certainly invite Attorney Johnson to comment on it if he wishes, my impression is that it is at that point that the lots became non-conforming, and if they were abutting, there was a period of grandfathering, if you will, or protection. And if steps weren't taken appropriately at that time to change ownership or to convey it out, or even if subsequently there was a common ownership that developed long after the zoning change, each one of those factors have both factual and conclusions to be drawn, and from those facts, different legal conclusions about whether or not a merger took place and forced, as Attorney Reed has indicated, forced by operation of law, 2 smaller lots now in common ownership to be joined. Might not have completely corrected the nonconformity. They might still have been subsized even when combined, but the law is very clear, and it's no secret, and it makes an abundant amount of sense that if you have a zoning scheme in place and there is common ownership, the law of the land is they've got to be merged under the right circumstances to at least minimize the nonconformity, make them less nonconforming to current zoning than what they would have been otherwise.
Anyone else have any questions?
Yeah, let me go
All right,
back.
let's, go ahead.
First of all, to answer your question, you weren't here for 2017, but that was the same petitioner. At that point, he had a purchase and sale for the property, and for one reason or another, he purchased it, I believe, last year, I think, 2022. And then I have a question regarding, okay, so if a relative had not owned 520 South Main Street, and all this didn't happen with trusts and one person ending up unintentionally owning both parcels, would this, if that was just owned by the one person, this would still be an issue, correct? Because after the 1 acre zoning in 84,
Hypotheticals in these situations are really dangerous, but it sounds as though the premise of your question would suggest that they might well have been joined. But again, I think it's probably more helpful to stay with the facts we're actually dealing with and avoid the hypotheticals.
I'm trying to figure out if the fact that the lots were merged has anything to do with this in the end, because that lot in question, 147 or 6, that became unbuildable after 8 years following the 1984 minimum lot size.
That's the question that is really at the heart of this whole case. And did a merger take place? When did it take, if it did, when did it take place? And again, those are facts that might get developed at the land court if the court permits it. The court, like Commissioner Florence, when examining the commissioner's decision, and if hypothetically you were to affirm his decision, they'd be looking at the underlying reasoning, which doesn't really get that far into the merits. It's, have you shown to us that you had no common ownership? It's your burden, Mr. Property Owner, and if the commissioner has not got the information in front of him to sustain that burden, arguably he's within his rights to deny the permit. So.
Let me rephrase the question. Say we have a hypothetical 0.65 acre piece of land that's not merged with anything else. It became undersized after 8 years of the zoning change. Would that still be appealable at this point and be able to get a building permit?
I'm, again, going to politely duck that question. Happy to talk to you up in the office off the record, but again, those aren't the facts we're dealing with, so I'm not sure that, happy to meet off the record, but I'm not going to shoot from the hip on this one.
I guess I'm not really sure where I'm going with that, but the fact remains, nothing has changed on this appeal from 2017. And for that reason, I don't know if we're taking account here, but I'd be against overturning the decision for that reason.
Let's give Attorney Johnson a chance. I don't know if he wants to speak to any of the comments that have been made, and public comment is still open.
Okay.
I would prefer to finish when the rest of anyone else who wants to speak.
Okay.
Does that make sense?
I have to give the same opportunity to Attorney Reed if he would like to speak.
Does any other member of the public want to speak before I address the issues that have been raised? I don't mean to be taking your job, Mr. Chairman, but
I see a hand behind you. I can't see who it is.
I just want a clarification of the issue. I've heard, I'm a little confused now. There were two basic points that Attorney Reed made. One was the 30-day stuff, and we addressed that, and who knows. The first one was common ownership or common control. If there were common ownership or common control, then these lots would be merged.
Right.
Correct?
no. So let's take a step back. Mr. Florence was not satisfied with Mr. Dacey's affidavit. That saddens me greatly. But he signed a sworn affidavit that during his ownership, he distinctly had different beneficiaries for each one of his trusts.
I understand that. This is an if question now. Let's not go back. This is pretty simple. If there were common ownership, those lots would have been ruled adjoint, right?
No,
Merged.
No. And I'll tell you why. Well, which lots? So 520 Main Street has, 520 Main Street has a full acre of upland. And your bylaw specifically states that an acre lot is forever vested. And my argument is that if you have an acre lot that's improved by a house, by adding more acreage to it, you're destroying the vesting.
Okay, you're ducking my question. Okay, and so I'd
Okay,
like to call,
So if,
Right.
so if these lots weren't checkerboarded, then on that street, say the Sylvia brothers never did anything, then they would have ended up post-1985 change with half as many lots, because abutting lots that were in this particular subdivision, generally a little bit more than a half an acre, they would have merged, so 2 lots would have become 1, 2 lots would have become 1. But my position on the facts on this case are that they were successfully checkerboarded, they maintained their checkerboarding scheme, and the operative date that you have to look at commonality of ownership is on the date of each zoning change. That's the language of your bylaw.
I understand all that. And I
Okay,
heard you.
good.
And thank you. I mean, you articulated it very well. It doesn't answer my question. Okay? My question is, if there was common ownership, they would be merged. That's a law, right? That's a law, okay? So the issue before us is, was there or was there not common ownership, right? I mean, that's one of the issues in front of us.
That's one of the arguments, yes.
One of the issues, and I'm focusing on that, okay?
Right.
And from what I understand from all the attorneys, that nobody can prove whether it was common ownership or not. Is that correct?
Well, I say that Mr. Dacey's affidavit.
I know what you say, and
is-
I've heard
is-
what everybody says, but.
Well, I'm
from-
saying to you that that's my proof, and I think that that's sufficient.
And I accept that, I understand that,
and you-
okay? And the other lawyer doesn't accept that, okay?
Right, but it's not up to either one of us. You're the fact finder, so you have to decide whether you like Brian Dacey's affidavit more than Mr. Florence did.
Okay, so
And
that
we
point-
will live with that decision and take it to the next level.
I understand. So the point number one, point number two being the 30 days time. Point number one rests on the affidavit by Mr. Dacey, Brian Dacey, of what he believed, but nobody can prove it other than that affidavit. There's no proof other than that affidavit, correct?
Well, do you think that Mr. Dacey would have borrowed all that money for half as many lots?
Hey, I'm not a lawyer, but I'm just saying.
Well, but
Okay,
you have some common
So wait a
sense.
minute. So the building commissioner said, that's not good enough proof.
And that's his factual determination.
So therefore, the lots are merged, and I believe that's what our commissioner said. I'm just trying to get to the bottom of
I believe what
this.
he said was he wasn't satisfied.
Okay, right.
Okay.
All right, I understand. Thank you.
Thank you.
Go ahead, Denise.
Well, didn't the family itself that says the ownership of Lot 7, that was given to the 3 daughters?
Right, families, if my wife and I own property next to one another,
But the point is, the owners created separate entities.
Turn your microphone on. Sorry.
after the death of Mr. Woods, they re-separated it out.
Right.
And,
So it-
and contrary to what Mr. Reed argues, I would argue that the 3 daughters were free to do what they wanted to with the lot, and the mother was free to do what she wanted to do with her house. It wasn't commonality of control. Families do get along and families don't get along. But the 3 daughters could have sold that property, and they did ultimately, and the mother sold her house ultimately. So I would suggest to you that when the mother deeded it to the daughters, there was no longer any commonality of control. And my argument is that the commonality of control has to be at a time in which a zoning change has taken place. It's a legal argument. But the fact that the mother owns the house and the daughters own the lot next door. That's not commonality of control. Okay, and,
So the daughters ended up with a lot that wasn't buildable.
well, we
So-
think it is.
I'm just looking at the square footage and what the.
So let's go ahead and close public comment, just for the record.
Chairman, this is.
Oh, sorry,
this
yeah, sorry.
gentleman.
If you want to come up and speak.
Does Attorney Reed want to say something first? I was waiting my turn, I'm sorry.
However, you guys refer to it.
Thank you. I won't belabor the issue, but perhaps in response to some of your questions. With respect to 520 South Main Street, the fact that that lot was vested with protection from the zoning amendment doesn't mean that it can't be merged with an adjoining lot. The grandfathering provisions protect you from zoning amendments. They don't protect you from subsequent changes of ownership that result in the merger of lots. The vested lot did not lose its grandfather status by the addition of additional land that made it less nonconforming. That's not the law. A lot that is perfectly protected by itself can still merge with an adjoining land if more land is brought in to make it more conforming or less nonconforming. With respect to the Mr. Dacey's affidavit, even if Mr. Florence was satisfied that that was sufficient to get him over the hurdle, it doesn't change the fact that there was the subsequent ownership by the Woods family. And whether you look at the entire family or just Marjorie Woods, she owned the two lots by herself as the sole owner for a period of 2 years. And that, without regard to any of the other issues, is common ownership of the two lots and results in the merger of the two lots. And that's irreversible, other than by variance from you, which was applied for in 2015 and was withdrawn. I don't know why, whether they just had a surge of common sense or whether you talked them out of it, I don't know. But whatever reason, they applied for that variance because they knew they had merged. They asked to unmerge them, and they withdrew that request. It didn't go forward. Thank you.
Sorry to try your patience. I'm Admiral Harold Robinson. I retired from the Navy to all of this mess, and it seems like it was less dangerous being in Afghanistan, but maybe that's just my old age catching up. I apologize. So,
Can you state your address for the record?
my address is 155 Beachleaf Island Road, Centerville, Massachusetts, 02632. And so I remember that at the previous session dealing with the issue back in whatever year that was, it's grown old with each other here, that the one person voting to grant the appeal, everybody else voted against, the one person stated that he was concerned that the daughters, that the Woods daughters, who I don't know, had depended upon that lot as part of their inheritance. And he wanted to have some I think the term he used was common sense compassion for those girls. Trust me, I think I understand common sense compassion. But the girls, who are grown women, just to be clear, I'm just was quoting a previous statement. Those women have gotten their inheritance. They sold the property. They've received what their father and ultimately their mother had hoped for them. So that issue, I hope, is we move on beyond that. But that was the issue back in, you have the dates in front of you. And I'll thank you very much. Sorry to try your patience, but I've traveled a long way to get here.
Thank you.
Thank you.
All right. Any more public comment? All right, seeing none, I'll just reference, there were 2 letters that were referenced by Attorney Reed that he submitted memos that are in the record. I'll make a motion to close public comment.
Second.
All in favor?
Aye.
All right, public comment is closed, brings it back to the board for deliberation. Herb, are you still in the same position?
I am, and I just located in the 200 pages of submission, the Darcy affidavit, and to me, it really doesn't say anything. So yes, I am, to answer your question, still in the same position.
Paul?
Satisfied.
Denise?
Feel the same way, yes.
Aaron?
You know, I don't have the, it's very difficult to decipher between attorneys and what was intent back in 1984 to honestly make it, I don't know, I can't, we have a piece of land out there that is, again, I understand in today's zoning is not buildable by today's zoning standards.
By
but
right, it's not buildable by right.
Correct,
but
correct.
It could be buildable,
Sure.
it's not by right through
So an
common.
applicant with a half acre, 0.64 acre would come to us for special permit or variance, right?
Yeah, or a 40B.
Or 40B to say, I have a piece of land here that I'd like to build a house on that doesn't match or meet the criteria for today's zoning. And we would make a determination based upon that, whether or not we would grant a, you know. So, all the other stuff in between here is, I don't understand it. I'm not a lawyer. It's very difficult for me to decipher what, both attorneys, I understand their points and they seem to make sense. I look back in 1984 to see that a subdivision was executed, plan was signed and approved. Over the years, the lot has clearly been defined as Lot 7, Lot 6, Lot 8. I don't know if 520 South Main was considered in that subdivision or not, but it's clearly been defined as a lot, in my opinion. And now here we are with a owner looking to put to come to us with a building permit. And so, I don't know. It's just very, very difficult. There's, it's.
So would you feel more comfortable if they were coming before us asking for a variance with proposed what they were going to build? It sounds, is how I'm.
Well,
I'm
but we
not putting
can't
words
get
in
to that point because the building commissioner denied the building permit.
Right, we have to rule.
Right, I mean, the mechanics that are in front of us are one thing. This is a denial of a building permit.
Yep.
That they're asking to overturn. It's not a variance saying, hey, we want to build this on this lot.
Yeah, again, we're never going to know at this point. We've had an affidavit from who was the trustee of a trust, right, of Thornberry. And at that point, it seems like the trail runs dry in terms of determining who is rightful ownership, and where I think the commissioner became, it sort of reached the end of the line for him at that point, was because we can't determine if there's common, ownership of this particular piece of land. I don't know if it ever will.
Well, I was just gonna say, it can't be common ownership if they sold off one part of it.
I would agree, but I think that's,
I mean,
I think that's.
just zoning. I mean, they're merged for zoning purposes. They're not merged for ownership
Right.
purposes.
Right, so recall in another town, in Katuitt, we had a request for a dock.
I recall it.
After, right?
Yep, I think
But the time
the
period.
woman's here, isn't she?
The time period changed, right? They could have had a dock anytime they wanted one, but all of a sudden, the zoning went in and said, you can't have any dock anymore. So they had to come before us for a variance. Well, it's the same way here. They could have built on it initially, zoning law changed, now they can't. So they have to come before us with a 40B or a variance or something like that, and they haven't yet.
Yeah.
All they have is the building commissioner says, I can't make the case, so I don't agree with it.
Sends it
But
to
is
us.
but that's not an option for the petitioner, is it to just,
They could draw plans and come before us, but we have to grant them a variance, which is the three-pronged
They're not
test.
in front of us with a
But
variance.
that's not what's before us right now.
That's not what's before us.
I understand all that, that's not what's before us. What I understand is that that the building plans were submitted to the building commissioner, and he denied it, correct?
Right, so you're gonna uphold them or not?
Yep, I
That's
get
the
that.
issue.
He
Yep,
doesn't grant the variances.
That's the only issue in front of us.
Yeah, but I don't think, I still don't think they could come before us with building plans and be seeking a
They
variance.
could.
Sure they could.
They have every right to.
Sure.
To come for a variance.
Still has to meet the 3
Yeah. I mean,
Yep,
we-
well,
we have
I
to-
understand that, I would have, yep, I understand that piece of it, I just, to me, it doesn't, it seems like that's sort of happened already because plans were submitted. I know they didn't come to us, but I don't know, I'm
Plans were
unclear.
submitted,
Yep,
they were declined,
yep.
so now they have a recourse, and they haven't taken that recourse yet.
That's not what we're doing here?
No, he's trying to overturn the building commissioner's decision.
We're just ruling on the building commission.
Yeah,
That's the
okay.
only issue we're
All right.
ruling on, okay? Not whether it's right or wrong or whatever.
According to the current zoning. it
Attorney
is.
Johnson, would you like a vote on this? I didn't really get a strong sense of
What-
where my board members
I'm
are pulling.
sorry, I thought public comment was closed. I wouldn't want you to violate your rules and give me another reason for appeal.
He's not asking for more comment, he's just asking if you want
Want us to vote on this? I'm not sure how you're feeling about the pulse of the board.
I'd love for you to vote on
Okay.
it, because Judge Rubin is waiting for us.
What happens with, if again, if the vote stays to uphold the building commissioner's decision?
Right.
What are Attorney Johnson and the petitioner's options at that point?
That's up to them, but
Yeah, they go back to the land court.
Yeah. Yeah, I don't know.
In the end, it doesn't really matter right now.
Right. It doesn't rule in our.
Okay.
I know, well, yeah, I mean,
Let's go.
So I will, I'm going to make a motion to uphold the building commissioner's decision as stated in appeal number 2022-055, meaning a yes vote would be a denial of the overturning.
I will second that.
Roll call vote. Aaron Webb?
Appreciate that. A yes vote is to confirm.
Confirm the building commissioner's decision.
Man, you know,
You can
yeah,
pass.
yeah, I'll pass. Thank you.
Denise?
I'll pass.
Yes.
Paul?
Yes.
Yes.
And yes.
Aaron?
So I'm going to say no.
All right, so it's 4-1 to uphold the building commissioner's decision.
Okay.
Thank you, Commissioner Florence and Attorney McLaughlin for being here tonight. All right, moving along in appeal number 2023-001, Centerville Gardens 2 LLC has petitioned for a variance pursuant to section 240-125B1C and E variances 240-107 wireless requirements, Article 4 site plan review, and MGL Chapter 40A. The petition seeks to construct a 110-foot above ground level AGL monopole style tower with the capacity for at least 4 wireless communication services providers, together with related amplifiers, cables, fiber, and other associated antenna equipment to replace the existing tower at 1047 Falmouth Road, where 30 feet is the maximum height. The subject properties are located at 36 Wequaquet Lane, Centerville, and 1060 Falmouth Road, Hyannis, as shown on Assessor's Map 250 as parcels 023-T00 and 023-H00 respectively. The parcels are located in the Residence D1, RD1, and Highway Business HB zoning districts respectively. Would you like us to read in the special permit request as well and do them concurrently, or do you want to?
Yeah, let me introduce myself. My name is Edward Parry. It's P-A-R-E. I'm an attorney at Brown Rudnick, One Financial Center, Boston, Massachusetts. I think it probably makes sense, Mr. Chairman, to open both. The facts are going to be, the evidence and the facts are going to be identical for both requests, so that might make sense. And then we can distinguish between the variance and the special permit.
Perfect. And that's acceptable, correct? Yeah, okay. So I'll also read to the record appeal number 2023-002. Centerville Gardens 2 LLC has applied for a modification of special permit 2012007, condition number 5 pursuant to section 240-125C and MGL Chapter 40A. The applicant seeks to allow commercial activity and associated site improvements within a portion of the site located within the RD1 zoning district. The properties are located at 36 Wequaquet Lane, Centerville, and 1060 Falmouth Road, Hyannis, as shown on Assessor's Map 250 as parcels 023-T00 and 023-H00 respectively. The parcels are located in the Residence D1, RD1, and Highway Business HB zoning districts respectively. And sitting on these two appeals will be our regular members, Herb Bodensee, Paul Pinard, Mark Hanson, and Aaron Webb. All right. We're ready.
Good evening again. So let me explain why we're here, number one. So back in 1999, almost 24 years ago, I appeared before this board to actually zone the existing tower that's located at 1047 Falmouth Road. So I want to explain sort of why we're here. So that existing tower, which is shown up on the plans, and all of these materials were submitted with our voluminous application. 1060 is the property to the north on the plans, but if you look to the south, which is across Falmouth Road, you'll see the shadow of a tower sticking up above the building, right at the bottom of that plan, sort of at the center. So that's the existing tower that was permitted back eventually in 2000. Well, that lease is running its term. The lease was for 5-year terms to a maximum of 25 years, and that 25 years is coming up next year. Crown Castle, who is the applicant and my client in this case, is a provider of wireless infrastructure. So they own the tower, they own the infrastructure around the tower, and then they lease space on the tower, vertical space, to carriers such as AT&T, T-Mobile, Verizon, and now there's a new carrier, Dish. So back in 1999, 2000, Sprint Spectrum was my client, and we zoned that existing tower, which is shown as the shadow there on the plans. That lease will come due in June of 2024, so Crown Castle, as a good landlord for its existing tenants at 1047, needs to find an alternative location. That alternative location is across the street at 1060, obviously also in a commercial area, and sort of the same design as we had at 1047. That lease will come due in June of 2024. Crown Castle owns the tower, and at the expiration of that lease, the tower will be removed. Just a point of note that we have been in zoning for about a year and a half to date. We have gone through the Cape Cod Commission. In November of 2022, we received Cape Cod Commission approval for what I call the relocation of the tower from 1047 to 1060. What's a bit odd about the lot at 1060 is while it's one lot, it has two addresses. And of course, it had to be divided by two villages, so the front portion of the lot is in Hyannis. The rear portion is in Centerville. Of course, to further complicate matters, the property is also bisected by two zoning districts. So in the front, we have the HB Highway Business, and in the rear, the Wequaquet Lane piece of the property is in residential. Now, when the property owner came in to put on that commercial building, he was granted a special permit for the property. The reason we're here to seek an amendment to the special permit was that this board placed a condition that there'll be all the commercial development would take place on the Falmouth Road portion of that one lot in the Highway Business District. Likewise, the condition states that there should be no development or clearing. It should remain in its natural state out to Wequaquet, except for an access drive for construction purposes. As Crown Castle looked around for alternatives, obviously we look for existing structures first, in accordance with the zoning ordinance. There are none, and we go through our alternative sites that were considered. This property was particularly interesting because it's commercially developed. We have parking area right up to the residential portion. And what we'd propose to do is to put a gravel driveway in, extending from the paved area, and then do our typical tower design. The difference between this use and just a general commercial use is the federal law which governs telecommunications, the Federal Telecommunications Act of 1996, which I know you're familiar with because you've dealt with it over the years. So I don't concede that this is a commercial use going in the rear. This is infrastructure for the public use and the public benefit, as I lay out in my legal briefs. So I'll run through what we're going to be doing at the site, and we'll flip through a couple of pages in if we can. So if you look to the rear of 1060, you'll see the gravel access drive off of the, oh, it's down a little bit for now, yep, off of the paved area for the parking. So we'll access the site across that gravel drive, and in typical fashion, we have a 50 by 50 compound which will house the tower and each of the co-location slots. If we get on, Anna. Maybe drop down to A5. So this is the depiction, getting rid of all of the greenery so that we can see, what's taking place. As I said, the gravel drive will come off of the asphalt parking area. We'll have a turnaround, which is indicated there by that rectangle that jogs out, and then access to the compound, which will be surrounded by a 8-foot-high wooden fence and include some acoustical barrier. What we did to address the Cape Cod Commission's fall zone requirement is that we shifted the tower, which is represented by that little black dot, kind of in the, exactly, so that we could maintain a 110-foot fall zone to the residential property lines. What was also interesting, our engineer noted, was that the site was previously developed with a dwelling, and you can see that it's not quite as dark, exactly. And there was also a little outbuilding to the right. So we're dealing with pre-disturbed areas and pre-developed areas. The only reason I raise that is because this property had been developed in the past, and while there was a special permit condition, we're seeking to modify that special permit to allow for this installation. If you take a look on the right-hand side, that's the elevation of the tower. We're proposing a 110-foot monopole. It'll support the equipment and antennas of at least 4 carriers. There are 4 carriers, as I mentioned, operating in the market: AT&T, T-Mobile, Verizon, and Dish. Sprint no longer operates. They've merged with T-Mobile. They no longer operate independently. They merged with T-Mobile, and Dish is a result of that merger and regulatory approvals. We go to A6. This is a better depiction of the gravel access drive with the fenced-in compound. Tower, again, is located off-center on the lower left-hand corner, and each of those pads eventually will be occupied by one of the co-locators on the tower. We provided a landscaping plan in the discussions and eventual approval with the Cape Cod Commission, so we're very specific about the types of plantings, how they were arranged. We spent quite a bit of time going through detail there. So at least you'll have some screening of the access drive. Likewise, as I said, it's an 8-foot-high wooden fence. You'll see the dark line to the north face of the wooden fence. That's an acoustical barrier. I mean, where we want to be good neighbors. We understand that this may cause some noise. So we've agreed to implement some acoustics by placing sound barrier within the fence to shield from the residential area to the north and northeast. flip back a little bit. Go to A4. These are a little difficult to read up on the screen, but if you take a look, what we did was we identified how far away each of the buildings, properties, residential properties are from the tower itself. And I think the closest is 176 feet. This also gets us a nice setback from Falmouth Road. It's 319 feet from the road. In working with the Cape Cod Commission, there was a real emphasis on, avoiding any clearing, and I would anticipate that this board would feel the same way. So we kept the tower in an area which either had been developed in the past or is part of that commercial development, rather than get into the trees and have to do any sort of clearing. Go to A7, please. This is just a depiction of some of the plantings and obviously the wooden fence with the gate to allow the carrier's technicians to go in and service the ground equipment. There's a lot of details on the plans. We can certainly go into any questions members of the board may have. If we could, I'd like to go to Exhibit 21. Are there any questions on the plans before I leave? We can always bring them back up, obviously. But
I've got a couple questions. So I'm just trying, so you said we're 319 feet from Route 28.
Correct.
Where is that being measured from?
Street. Can I introduce, Scott Adams is here with me. He's sitting up at the desk. He's our civil engineer.
Thank you again, Scott Adams with Advanced Engineering. There we go. Scott Adams again with Advanced Engineering. I was just waiting for the nod, so to speak. So as is shown on C1, the summary zoning table, there's an L asterisk that says the dimensions are measured from the edge of the monopole, the face of the monopole to the property lines or whatever we're indicating. And in this instance, yes, it would be the face of the monopole to the right-of-way line is the 364 feet.
And so what's the distance from the edge of the fall zone to 28?
It would be 110 feet less than that, so 254 feet.
So that falls within the 300 feet. So I would argue that we cannot grant you a variance here.
Why is that?
Because you're asking for a use variance within 300 feet
We're
of
not.
28.
We're not. We're asking for a height variance in keeping with how the town deals with towers. So
But when I read 24125E, are we not, so we're saying that doesn't apply here?
it does not.
Okay.
The planning department's position and this board's decisions in the past require only a height variance that antennas are allowed throughout town. So we need a height variance from the maximum height of building height in the zoning district, which is 30 feet, which is what we requested. A use variance is not required. Even if a use variance was required, and I know this section because we had a lot of discussion about this, it would be the pole would have to be less than 300 feet from Route 28, not the fall zone. The fall zone is something that the Cape Cod Commission has as part of their requirements. You don't. There's no requirement.
But it can't be used for anything else. That fall zone is a commercial space required for a commercial antenna to be there.
It's not because there's nothing in your ordinance that requires that. That's the Cape Cod Commission, I don't want to say suggestion, but their technical bulletin seeks a one-time height variant, the one-time fall zone.
But they're restricting it for any other uses. Its only use is for, that land area is going to be for wireless communication purposes. Can't be used for anything else, right? The fall zone? Or can you build in the fall zone?
You could build in the fall zone, sure.
Okay, just can't be a house, or what?
Well, I don't think a house would fit, but yeah, you could. I mean, can people build within a fall zone? Absolutely.
Okay.
I mean, mean, if you take a look at the photo up top, this is the existing tower across at 1047. It's probably not more than 10 feet from the building, and not nearly 300 feet from Route 28.
Okay.
So the position of the town's position on towers is you need a height variance because the use is permitted. The 1 times tower height fall zone is a Cape Cod Commission guideline.
Okay. So because zoning is silent on the wireless towers, that's how we're saying the use is
That's,
allowed?
that's what the town says.
Okay. Sorry to interrupt.
No.
Oh, sorry, go ahead, Paul.
Why 110 feet versus the current 30?
Well, 30 feet won't work, and I'll bring up our radio frequency engineer, but what that? Please don't. All right, I can handle it then. So this tower across the street at 1047 is 118 feet. Now, I'll give you, there's an 8-foot difference in elevation going to our lot, so it's a net wash.
That one's 147 feet?
118.
Wow, it doesn't look it, but okay.
Our 110 won't look 110 either then.
I'm not doubting it.
Yeah.
It's a full tower.
Okay, sorry.
Any other questions? Oh, that's fine.
Anyone else have any other questions at this point about the site? And so just to confirm, so all of the ground-mounted equipment and things are outside of the 300 feet?
Correct.
Okay.
And believe me, I spent a lot of time on that. And, you know, we had lots of discussions with the planning staff, and I think if you take a look at our site plan, most recent site plan review decision, it explains the relief we need, an amendment to the special permit and a height variance. If we needed the use variance, I'd be here asking for it because
But you couldn't
our
ask for
application
it.
would, well, we
couldn't
could.
grant it. We cannot grant a use variance.
Well, you can't, I mean, I don't want to get, but you can because of the Telecommunications Act.
Yes. Yes, you could override us, yeah.
Right. But that's a hypothetical. I think you dealt with enough hypotheticals in the last application. So the tower will be 110 feet and will contain space for at least the 4 major carriers. The tower doesn't have to be lit for FAA purposes. The emissions comply with the FCC requirements, and there were reports in, as I said, we do hear about our voluminous application filings, but if you take a look, you'll find that everything that I'm addressing is contained and documented. Likewise, we provided a noise study in addition to the sound barrier. And the noise is really generated by backup power generators. The electronic equipment that the carriers use is just that, it's all electronics. There may be a humming noise when you're standing next to it, but it's really the generators. And you know, the Cape Cod Commission, if you take a look in their decision, is seeking to, or expresses a preference for 1 generator. And it's something I think we're going to have to talk about because 1 generator is going to be bigger and noisier than, say, 1 generator or 2 smaller generators that just deal with each carrier. Not all the carriers install generators, so if we oversize it, we're truly oversizing it. Backup power is important, though. You know, these towers and their antennas, you know, service 911 calls. AT&T provides FirstNet service for first responders. It's a dedicated network that AT&T provides on behalf of the federal government. So it's important that these sites are what we call hardened, so that they're always available even in times of power outages. Many times, cell phones are the only means to make a 911 call or an emergency call. Why don't we go to Exhibit 8? So as part of the Cape Cod Commission review and approval or review of applications, we're required to conduct a balloon or a crane test, which we did. This was done not only in conjunction with the Cape Cod Commission, but also the Town Planning Department and the Town Historic Commission, so that we if there were areas that were particularly sensitive, we could get photographs and renderings from those locations. So what we do is we raise a crane up to the height of the proposed tower, 110 feet, and then maybe scoot down a little bit and we can see the crane. And it's a big If you can get to five, there you go.
It's just this.
So back in December 2021, we've conducted this crane test. The balloon is at the top, indicating the 110-foot level. The Cape Cod Commission requires others, a flag 20 feet below that. And that little antenna sticking out is what we did to do the drive test on behalf of AT&T. So at the same time the crane was up, we could conduct a drive test to show the commission and this board that the site was actually necessary. So if we could flip back just to the beginning. So obviously along Route 20, yep, a couple more, just. Yep, thank you, Anna. So the red dots indicate where the balloon or the crane was not visible. Yellow is intermittent or seasonal visibility, and then green, obviously, it's going to be visible. As you'd expect, along Route 28 Falmouth Road, there's going to be visibility of the tower. That's going to be where most of it is. And I'd leave it to the board to flip through, the particular locations. It's a little hard to do it on the screen, but Anna, if you could just scroll down a little bit, just so the members of the public and the viewing audience can see. So what we do is on each photograph, you have an existing and then a simulation. And existing with the crane, obviously, we're going to get visibility there on 28. Then that's a digital depiction of the tower. So that's a 110-foot tower, fully loaded with all 4 carriers.
Is that accurate to the color it's going to be?
Yeah, it's a galvanized. It'll weather a bit. If you look at a typical tower, it starts off with a gray. It has a bit of a shine on it, and then it'll weather to.
And the antennas are going to be white?
What's that?
The antennas are going to be white?
Yeah, the antenna's like an off-white color. Things can be painted. Anything that's painted is going to require some maintenance. We typically find that you let it be gray. I mean, I've had instances where people have suggested blue. I could tell you that's a mistake. It'll weather. The antennas are, I don't want to say they're changed frequently, but the technology changes. Carriers use different antennas. It's going to look like a tower with antennas on it. Another picture of the crane. Then the tower. So this is where we start to get some of the visibility is, not quite apparent from, we take these from public ways. This is the existing location from Wequaquet Lane. And if you flip down to the next one, Anna, you'll have to look through the trees to, find the balloon and the yellow flag if you can see it. But you're going to have some level of visibility through the trees. When leaves are on, obviously it'll be less so. I'll leave it to the board to go through the rest of them, but you'll see that most of the visibility, or at least the full-time year-round visibility, is along Route 28, as you'd expect.
Just a quick question
Certainly.
while we're on that. So just to sort of get the detriment to the public out of the way, during the process when you were working with the Cape Cod Commission, I'm assuming that anything would have been worked out with any concern from the residential side of the neighborhood, any abutters that may have come forth at that time?
Yep, there were. Yeah, there were, I want to say there were 3. There could have possibly been 4. We were doing Zooms. So from what I could count, Ms. Goodwin, who I believe is here, if I recognize her from Zoom, is the closest abutter. She expressed concerns with visibility, but again, she's at ground level. I'm not saying she won't be able to see it, but it'll be intermittent. There was a gentleman, I'm not sure if that gentleman's here this evening, who also expressed concerns. Some of the concerns deal with the health impact of the tower, and I think as this board is aware, that's not something that was within the jurisdiction. You have a report that shows that we fully comply. These are low-powered. As long as we comply, I think in this instance, we're at about 19% of the maximum. There was a town representative that was concerned about real estate values and emissions. Obviously, emissions off the table. And I will have Judge Valentine come up. We did have a real estate expert do a study, and that's also in your packet. Let me get at Exhibit 14 if you're interested in that. That was it. If there was a fourth one, I don't recall.
Okay, thank you.
Oh, I'll
Other questions? Sure.
Noise, did anybody express, any of the abutters express a concern for noise from the generators?
Not that I'm aware of. I mean, it's not that I recall. They may. We voluntarily put in the noise attenuating systems for the generators. The generators test once a week. Those can be set to timers. They can be done. As a matter of fact, the Cape Cod Commission conditioned it on certain, periods of the day and on weekdays. You're going to have a lot of generators fired over there. It's a commercial area. We're no different than anybody else. But by using the wooden fence and the sound attenuation, especially to the residential side, it'll shield them.
Yeah, you mentioned that before.
Yep.
You mentioned that it was an 8-foot fence?
It is.
Yeah, don't we need a special permit for that?
That came up during the Cape Cod Commission. The gentleman that chaired the subcommittee asked me the same question a couple of times. He was clearly interested in the fence. We went through and didn't find a fence height restriction for the zoning district that we're in. But I'm curious that you raised the same question. We didn't find anything in your ordinance to deal with that. So that it could be because of the district we're in, or, I mean, to me, the 8-foot fence for neighbors is better than a 6-foot fence.
If I was a neighbor, I'd want the 8-foot fence.
And again, we know we're going to have some impact. It's also obvious that there are residences to the north, and that's what we sought to protect.
This is probably an question for your whatever expert you mentioned. Does it affect the cell phone reception for people really close to it, negatively? Are they going to have a problem because the cell phones project out that way, but
They
there's
do.
a kind of a...
Yeah, you do get leakage down, but we will have Sohail Usmani is here.
Not the sound so much, but a lack of coverage really close to the cell phone?
Yeah, I'll let him describe whether, because, the question always is, if you're standing directly under the cell tower, will you get coverage? I believe the answer is yes, but I'll leave him to that. But the reason these are low-powered is the beam is pointed towards the horizon, and then if you think of it like a flashlight in layman's terms, the power of the light goes out, and then it kind of creates that cone, if you will, and that's where the cell phones connect back to the antennas. So, but I'll let Sohail answer that.
Thank you.
That specific question. Other questions? Can you go to Exhibit 5? So what you're going to see on these maps is a depiction of AT&T's coverage. AT&T is not located on the tower at 1047, nor is Dish. Two carriers that are on the site, T-Mobile, as I said, Sprint merged with T-Mobile, so eventually they'll combine their network, and Verizon. So because they're already providing coverage, it's difficult to come up with a gap for them. But if we take that tower off air, we're going to have a lot of Verizon and a lot of T-Mobile. And leftover Sprint customers real upset because they'll have no coverage in the area like AT&T at this point. So I'm going to run through these maps, and then I'm going to have Sohail come up for any questions you may have. So AT&T's nomenclature for Their cell sites in Massachusetts, it's MA followed by 3 or 4 numerals, and in this case, it's MA 1011. So the black dot is the proposed site. What AT&T is striving to do is to get to green. Green is good. Green is the best, most robust coverage. So if you look to the west on Route 28, you'll see a site called MA 5285. That's an AT&T site that's currently operating. So you'll see you get that big blob of coverage that propagates from the site. The reason they put the antennas around each side is to get a 360-degree pattern, and then the topography, the buildings, foliage block some of that signal. So sometimes it'll go a little bit further, sometimes not so much. If we can go to the next slide. So this is a depiction of AT&T's coverage if the tower is approved and AT&T attaches. Again, I'll give you the reference point. To the west, you have MA 5285, which is AT&T's coverage from that location, and then the black star entitled MA 1011 is from the proposed site at 1060. So you'll see it fills in nicely with green. You get orange so that people in their vehicles and outside can still make calls, do videos, whatever it is everybody does with their cell phones these days. So you'll see it fits a pretty significant gap for AT&T right along that area of Route 28. As I said, the other carriers are going to have similar footprints, but because they are providing coverage, we can't show the gap. But when we remove that tower and switch the power off, they're going to have a map that looks like AT&T. So that's the need for the site. I'll have Sohail come up with to answer any specific or technical questions that the board might have. Where is it, Sohail? Sohail works for a company called C Squared.
This little red.
Oh, I'm sorry. Sohail works for you can sit there, I think. Sohail works for a company called C Squared. You'll see their report is in your packets with more details, exactly what AT&T's coverage, population counts, size of the gap, et cetera. And again, rather than get into too much detail, you can either ask questions or we can have them run through specifics of the report. So Sohail?
Good evening, Mr. Chairman and the board. Just to explain briefly the different colors in the coverage plots, if you could, do you mind going back to the previous one, please? So in this slide, as Ed mentioned, the proposed site coverage is not there. So you see a lot of white spaces. The green color represents the stronger threshold, which will give you typically in-building coverage. So when we're inside buildings, you'll experience the green signal, which is, as AT&T categorizes, minus 83 dBm. And the orange, which is a bigger piece of the pie, if you will, then that extends farther and from minus 83 to minus 93 dBm. The white spaces that you see, that does not mean that there is no coverage, but it's not what is termed as reliable coverage to maintain either a voice call or a data session or somebody who's browsing. So the white spaces, when I show white spaces on a map with the thresholds, it just means that it's below what AT&T references as reliable coverage. And then in the next slide, you can see how well the proposed site tends to cover with the green and the orange colors. I can. That star is supposed to be blue. I don't know why it appears black. So the whole purpose of the proposed site and the existing site in the legend is to show, so MA 1011, which is a navy blue, colored star, that is the proposed site location. And it is located very, just where the existing site is in case of the other carriers that are currently providing coverage, which is right across the street. And once that site is decommissioned, because it's right across the street, it will mimic almost the entire coverage that the existing site is providing. So that I would call it, from a technical standpoint, an ideal solution. You take down one and you bring the other. So light off, light on kind of situation.
And Sohail, what about the height for AT&T? They're at, well, first of all, T-Mobile and Verizon are already installed on the existing tower, so when that comes down, they would get the top preference of the next two, and then AT&T will go below that. Sohail, my understanding from the testimony at the Cape Cod Commission is that AT&T would prefer to be up higher than its 87 feet.
They would, if they could have gotten the highest available or highest antenna center line on the tower, then they would. But in case of, carriers always prefer co-locations, and this is one of the case where, especially on Cape Cod, you're putting up a tower and you want to maximize and get as many carriers on board as possible.
So one of the reasons I mentioned we went to 110 feet was to maintain that fall zone, which was important, but also to maintain the carrier heights from the other poles. So the existing pole at 1047, I don't want to keep confusing things, but the height at the existing site is 118 feet. We were able to drop to 110. We were able to satisfy that fall zone, at least from the residentially zoned properties, keeping T-Mobile, keeping Verizon at their elevations. And unfortunately, there's only so much height. So it's at 110. It's, T-Mobile takes the top, Verizon takes the next. The only available is for AT&T as the third slot down. They would prefer to be higher, but then we deal with, we're putting up a higher tower. We're really not relocating the tower itself to a new location. And we really need to maintain the fall zone. I don't think the Cape Cod Commission was in a position to further reduce that, just to allow AT&T to go up a little bit higher. So there was a lot of discussion about that, and that's why I brought that up. If there are other questions for Sohail, he's not leaving, but have it happen, or I'll continue to move on.
Can I just answer the question that was asked about the
height underneath?
The vertical null. It is present if you're standing directly under an antenna, and sometimes you may get lower coverage or lower signal threshold than you would if you were in front of the antenna. But because of the inherent nature of radio frequency signal, there's a lot of reflection that goes on. So, I can use the phone, or we all use our phones while indoor. We can't see the tower, we can't see the antennas. So it's all due to reflections and glass and objects and different things. So it's all, it's very unpredictable. But the short answer is you would get signal and you would be able to make a call.
Thank you.
Anyone else have any other questions? Okay,
Good?
I think so.
Okay, our last witness for this evening is George Valentine. As I mentioned, you can find his report at Exhibit 14. George is a licensed real estate appraiser. His report was presented also to the Cape Cod Commission, since your zoning ordinance does take the impact on property values as one of the components. I asked George not only to submit his report, but also to come here this evening and just to report his findings. Again, he has a pretty lengthy report. With that, I'll turn it over to George.
Good evening. My name is George Valentine. I'm a certified general real estate appraiser in Massachusetts and Rhode Island. The applicant has requested that I perform a real estate study to determine whether or not there would be a negative impact on surrounding property values. And I summarized my findings in the report that you have. The methodology we use is typically called the paired sales analysis, where you would compare properties that are close to, sales of properties close to an existing tower, and then compare them with properties that sold without the presence of a tower to see if there was any measurable difference. I've included several studies around Massachusetts, one in southern New Hampshire, just because it was a very visible tower, and it's a bedroom commuting bedroom community to Boston, so I figured it was relatively comparable. The most significant evidence that I found locally was a condo sale in Falmouth at the Highfield Hall Gardens, or at the Highfield condominiums adjacent to the Cape Symphony. There was a 174-foot lattice tower located about 400 feet from a 2,400 square foot condominium, which sold in 2019 for $612,000 or $253 a square foot. Then I looked at the comparable sales data for condominium sales in that size range, and there was no very minor differential in value. The sale here adjacent to the tower was actually slightly higher than the median and average sale prices of similar condos in Falmouth. So I have looked at a lot of these properties. I've never seen any evidence that there's a diminution in value due to the presence of these towers. That's my finding.
Thank you. Anyone have any questions?
Thank you.
I'm just going to, Ann is bringing up one more. Thank you, George. So as we all know, I'm sure everybody up there has a wireless device. Everybody is using these nifty iPads. The demand for wireless services has just grown exponentially. They've become a way of life. My kids have never had a landline, probably never will. They've had the same phone number since they purchased their first wireless plan, and probably will never change their number. They take their phone and their devices with them everywhere. So this is really just driven by consumer demand. And in this instance, because Verizon and T-Mobile are already providing coverage, when that tower comes down, there are going to be a lot of unhappy customers. I don't come here tonight saying that the tower is going to be invisible. It's a 110-foot piece of steel that rises up above the buildings. But when we try to pick locations that make sense, I think in this instance, we did, again, the best we could. I think I know the Cape Cod Commission agreed with us. If you take a look here, you'll see that the rear portion where the residences are pretty well heavily treed. So you're going to have to look through the trees down at ground level to see the tower. It's not going to be invisible, but you're not going to see it like it's along Route 28. There is virtually little to no screening as to when you compare the tower at 1047. So we think we have identified and gone through the process to eliminate all other sites. AT&T needs the coverage. Dish provides no coverage. They have a footprint worse than AT&T, but I think you'll probably begin seeing applications from them as they develop their networks. This provides for co-location for all four of the carriers, so it reduces the need for tall structures, i.e. towers. And unfortunately, the tower across the street has run its life. It's going to be removed, and we need a replacement. When I approached the Cape Cod Commission and attended my first site plan review with the town, I said, well, the lease is going to expire in 2024, and everybody said, well, we've got plenty of time. Well, I think we've passed through probably about half of that time so far, and I'm just at my first hearing before the zoning board. So time moves fast. These towers take time to develop. Not just get permitted, but to develop. So we're really on a path where The tower is necessary, it's needed, and would respectfully request that the board approve both the height variance and the amendment to the special permit pursuant to the Telecommunications Act of 1996. Our applications are voluminous. I lay out all of our legal arguments. I go through the ordinance section by section as to how we satisfy the standards. With that, I'd be happy to answer any questions or any questions from the public. Thank you.
Thank you. Anyone have any questions before we open public comment? Go ahead, Aaron.
I just have a quick one. Just out of curiosity, what's wrong with the current location at 1040, is that correct?
1047.
1047, the Child's Building. So that tower now is under lease. Lease is coming up. Was there negotiations to?
There were discussions between Crown and the property owner. They did not reach agreement. The tower is older, and we're looking to put 2 new carriers on it.
So regardless of whether or not an agreement was done between the current landowner that the current tower sits on, there was an age issue with the tower itself? Was there, I mean, was it to the point where he was going to have to come down and be replaced?
Oh, I don't
even
know
if it stayed on the same property?
Oh, it might be able to stay there with T-Mobile and Verizon, but adding the other 2 carriers is problematic, and we need ground space for those carriers. If you take a ride by, or if you're familiar with the lot, it's pretty small and it's tucked in. The tower itself is tucked in behind the commercial building. I think T-Mobile's close to the tower, but I think Verizon's offset a bit. So it's a matter of ground space, and it's a matter of having a willing landlord. And we don't.
It's unfortunate.
I guess. But we need to provide the service.
I get it.
And we can't be held up by
yeah.
whatever.
Just a quick question. So is this emitting 5G basically, or is this?
Yeah, well, see, there's a little bit of a misnomer on what 5G is. So 5G is a standard. It's a speed, it's reliability. So it's really the frequencies that are being used. And I think all of the concern that we read about is the millimeter wave antennas, which are going closer to houses and so forth, where there's an uproar. We fully comply with the FCC. Will these achieve 5G speeds? I would think so, but maybe not with the frequencies you're thinking about. It's the way that each network designs its system.
Okay.
So 5G, it's possible, but it's a standard, not a spectrum, I guess.
Okay. And then what's sort of the useful life of the monopole? Like, how old was the other one?
Well, the other one's coming up on 25 years, and it's, still there. And I'm going to ask Paul Peckins, who's the client who came all the way up here from Virginia to be here this evening. He's a representative directly from Crown Castle, and he can answer some of those questions for you.
Good evening, everybody. My name is Paul Peckins. I'm with Crown Castle. I'm based out of our Houston, Texas office, but I live in Richmond, Virginia. Address?
Yeah, go ahead.
Okay.
Yeah.
12124 Richmond Street, Chester, Virginia, 23831.
Okay. Yeah, so the question was I was just curious just what the life of that tower will be.
So we look for the long-term permanent solution for these sites. And when we design the tower, depending on how many carriers it's designed for, that capacity could go for years. And the tower that sits there today, in a sense, the concept was a 25-year capacity or 25-year term. So it wasn't designed for as many carriers as the towers are now. Ideally, we're looking at a 100-year design. So we've got it designed for at least 4 carriers with the ability to go further. But that's where our initial input is right now.
And are you guys always responsible to dismantle, take this thing down if it becomes obsolete, or that falls on the property owner?
In this particular instance, it's on us.
Okay. That's all my questions. Anyone else? All right.
Thank you.
So I guess we can open for public comment. I don't think we received anything via mail. Correct, Jenna, Anna? Is there anyone here who would like to speak to this? Just come up to the podium, state your name and address for the record.
My name is Mary Ellen Goodwin. I now live at 10 Hazelwood Road in South Dennis. and I know that might sound funny that I'm here, but I was the previous owner that started on trying to fight this at 38 Waquacket Lane. And I'm very sad about this whole situation and feel some obligation to be here as well because the person that bought my property bought it feeling it was as special as I thought it was when I first bought it. And if it weren't for financial reasons, I would still own that property. So it isn't that I sold it because this was on the table. I sold it for financial reasons. It broke my heart to sell it. My daughter got married on that property, and it's a beautiful property. It seems to me that a lot of this is coming down to everyone else versus one property. And I ask you to consider, Mr. Chair and the board, that this is Cape Cod. This isn't New Hampshire. This isn't Boston. This isn't, people move here for a reason. I'm very saddened by the Cape Cod Commission's decision. I'm also very saddened that they make it very difficult for a resident to defend anything because I don't know how many times I reorchestrated my life to make sure that I was going to be present for a Cape Cod Commission meeting, only to log on to Zoom and hear from someone that had been postponed. Unfortunately, one of the last times that it had been postponed, it was impossible for me to be there. The time before that, I had rallied a group of people to be at my home, to be on the Zoom. I had even bought pizza to serve. And I get on and find out it's been canceled. It's very discouraging, very discouraging. When I bought that property at 38 Waquacket Lane in 2016, I never was notified about the Strawberry Hill Medical Center being built. Now, I wasn't opposed to anything being built there. That was a vacant lot that seriously needed something because it was an abandoned property that was full of needles and mold. But I never even got the opportunity to come and ask questions or find out information, and certainly wouldn't have been happy to or wanted to see a two-story building. A one-story building would have been great, but a two-story building definitely had serious impact on my property. I learned about that building when I saw a machine pulling trees out of the ground like they were toothpicks. And I'm running out going, what are you doing? You know, and that's how I learned about that. So they sent the notification to the previous owner, not to me. Same thing has occurred here. That letter came to me late because, of course, it forwarded from Centerville to Dennis. And Mr. Harrigan never got any notification. I received that letter January 30th. I immediately emailed the development, the people that sent the letter. I emailed every person listed on here the following morning to tell them that Mr. Harrigan had not been notified. I don't know why it took like another 2 or 3 days for an email to go to him to notify him, but that's the case. I even had to email a second time the next day to say, could you please at least confirm that you received this email? And then I got confirmation that they received it. It saddens me that, look, you can smile, you can laugh, you can think it's funny, you can talk about cell phone service. Never in my history of coming to Cape Cod, which I've come to every year of my life, and I am now 59 years old, I valued Cape Cod for the land, for the beaches, for the Brewster Flats, for the ocean. I vowed I wanted to live here someday because I loved the Cape so much and it had been so preserved. It's getting watered down badly, especially in this area. And you know, you can say people need cell phones. When I first moved there, I didn't really get the best coverage. And the funny thing is, I'm an AT&T customer. And at first, I wasn't really getting that good of coverage. But you know what? It didn't matter, because you know what? I had a landline. So if I had to make an important phone call, and I wasn't maybe having the greatest coverage day, which I'll tell you seemed to be the first couple weeks of July when the height of everyone is here, that seemed to be a thing. that you'd get a lot of drop calls for those weeks. But again, I had a way around it. I had a landline. It wasn't the end of the world. There's Cape Cod Commission, I thought, was developed to kind of balance how things need to develop as well as preserve what's special about Cape Cod. I'm very disheartened to see what their decision is. But I want to get more to the point of the height variance. First of all, got notification about the crane thing. December 17th, let's pick, a few days before Christmas when everybody's barely paying attention to anything but the holiday, and let's do a crane test. Thankfully, I was paying attention. I saw your pictures up here, which, they're so far away that it's hard to really appreciate how close they are to this property. I'd like to pass this picture up to you because it was taken from the window of my living room at that time. And if you're going to tell me that that wouldn't be highly visible, you can see the octagonal window that it was taken from inside. Not once has anybody come on the property or asked to view from my property, which was crazy to me. I invited people to, but no one came. I still would love it if all of you would go to the property and take a look at it and see what that height would look like from there. I could see it from the end of the 1,000-foot driveway all the way up. Yep. So you can imagine the picture of the full tower, if that was replaced in that picture, it's much wider than a little pole that holds a bulb, right? It's huge. Also, this 110, we took it down from 118 to 110. Isn't that only because the land elevation is 8 feet higher in the new location? So really, we're talking, it really doesn't, it's not lower, really. As a butter, it was never made clear when I was attending a couple of the Cape Cod Commission meetings that there was never any clarity about why the negotiations for the current property failed. I don't know why they're not renewing. Really kind of seems a little bit relevant to me, and yet no one has answered those questions. I don't think that anyone's going to die or not be able to make phone calls if the entire coverage area is in green. I know there's other locations. There's probably other locations that would make more sense. That is a residential zone parcel of land, 36 Waquacket Lane. The gentleman that lives at 46, Paul Cooper, asked me today in a text message to please let you know from him that he's highly concerned. He's had 2 surgeries in this last month, so he could not be here. He had a pacemaker installed. He's now concerned that the pacemaker may be affected by the RF radiation. And I know that that's a dead zone for you and that we can't really even look at that because, FCC can do whatever they want, apparently. Apparently, there was a special permit that was initiated for this property that's now on Falmouth Road and the parcel of Waquacket Lane. I don't know all the ins and outs of what happened back then, and poor Richard here, with only a few days of notification of this, has not had a chance to get legal representation or to look into the specifics of the zoning himself to feel if he had a chance to legally attack this. You said there was a condition that no further development would take place on the Falmouth lot, but yet this is further development. And I beg to differ you when you say that infrastructure is not commercial use. Let's be real. That infrastructure is for commercial use. There's no getting around that, and I'd like to challenge that legally. I'm I'm trying to see if there's anything else here that I had to add. I'm just highly, highly disappointed in all of this. There's not enough information. And after sending, first of all, conveniently, my email with all the pictures that I took during that crane test, never seemed to make it to Cape Cod Commission in time for the meeting. Subsequently, when I emailed them again, they did appear. I don't feel good about that, all right? I just don't feel good about that. I'm just asking you to remember that this is Cape Cod. We are in a very, very special area that is slowly falling apart and falling away, and not the Cape Cod that was supposed to remain Cape Cod and a special place where people would come. And by the way, on this real estate thing, I highly beg to differ with you on on values. I was a real estate agent, and there's no way that that does not impact real estate value. And I had been told by multiple people and by articles I read online that there was at least a 20 to 30% drop in value of a home that had a cell tower near it. And that was just near it, not on top of it. So I'll leave you to that. Again, the height is ridiculous, ridiculous. There are so many reasons why this is wrong, but I understand the only thing we can probably stand on right now, and the only thing that's in front of you right now is the height situation. So I ask you to use the fact that that height situation is there to deny this request. And I will just say I pray that you all do the right thing. And I'll just give it over to Richard, because now it's his property.
Good evening. Long night. My name is Rick Harrigan. I grew up here in Massachusetts. Used to live on the Cape. Lived here for about 8 years in the mid-'70s into the '80s. Moved to California. Came back this just past June. Bought a property here. I used to live here when there were not a lot of year-round jobs. And dream about owning my own home here in Cape Cod. And finally, I decided I needed to go away. I got on with the airlines, worked with them for 40 years, came out here with pension money, and bought a home. The end of June, 6.5 months, 7 months ago. I knew nothing about this. The first notification I've had, officially, Anna Brigham sent me an email Friday at 4:30 in the afternoon about advising me about this hearing, what was behind it. And I emailed her back saying that they were, you know, they apologized that they didn't send it to me, that they went from their certified abutter list, and I wasn't on it. And I was listed as the owner of the property as of January 1st, 2023. Their list was January 3rd, 2023, and I wasn't on it. It just seems to me that I've been here since June, and everybody's having trouble finding me for some reason. The notification was sent to the former owner, who sold it to me. We closed June 30th. You had hearings. I haven't been notified. I didn't know anything about this. How could this be going on for the last 6 months, and the direct abutter has no communication with anybody about this? I didn't see one photograph in your presentation, which was impressive, of my property, of the view from my property of this tower. Nothing. Everything is, you showed Paul's house, which is down the road from me. But I am right in front of this. I urge anyone here that wants to really see what this is, just take a drive down to Waquacket Lane. It's a private driveway. Drive on down and look at it from my front yard. This thing is going to be 110 feet cell phone tower. It's going to be 35 yards from my front deck. And I bought the property because it had a front deck that faced southwest and west. So I had sunset off the front and trees, beautiful every night. And sunrise in the back, on a back deck. Well, now I'm going to have sunset and a 110-foot cell tower right in front of me. It looks a lot bigger on these maps. We're seeing, you know, faraway photos. come and look at it up close. You will be shocked at how close this is. I've had 5 days to look into this and see what's really going. I've been reading a lot of information and going into the background. I read a lot of the committees hearing that you referenced in November, was it, of 2022? They talked about the fall zone and how close this was going to be to the fall zone. You addressed that, but it seemed like it was all talking about Route 28 in Falmouth. What about the fall zone to my property line? Does that not have anything to do with it? Isn't the fall zone so that if something, a tall structure falls, it doesn't fall into that neighboring property line? Because the property here that they're looking at putting this on, this is a map, town of Barnstable. And let me pass this around to you. I put check marks as to the property that they want to put the cell tower on and the check mark for my home. I'm sorry for the crudeness of my presentation. I've only had a few days to try to get up to speed and come in here and say something you'll understand. From the point of view of the direct abutter, no one has contacted me until Friday afternoon. How is that possible with this multi-million-dollar business going on? Unless they don't want to hear from the direct abutter. So what I'm going to show you, I'll give you this. This is the property that they're going to put the cell tower on. And then the check mark is my property. You can see exactly where. This is the property. This is 36 Bucket Lane. That's 38. Okay? Pass it down. And you can see in the corner of that printout that it's like a ½ inch is 34 feet. And I got my ruler out the other night, and I put my ruler on there, and it's 2 inches from across that property to my property line. So with my math, it's 136 feet. From the edge, from the back of the office building, and then they're going to put the tower there, somewhere in 136 square feet, or 136 feet. If they put it close to the middle of that property, then it's 68 feet from the tower to my property line. And the tower is 110 feet. No?
Could you explain this?
Yes.
Sorry to interrupt, but I just want to make sure that we all understand. This is your property here?
Yes, right here, the check mark. That's 38 Wood Crossing. I also own that property, but there's nothing built. I was here. This is in this area. This is 36 Wood Lane. Okay. Now that's what I'm talking about. See, 34 feet equals a ½ inch there. From there to there is 2 inches. That's 136 square feet. Now the picture you have there, the crane was about here. Okay, the crane was here with the balloon. Now that is. Yes. No. Hey, so there you go. You know, the crane was like here with the balloon. This is the middle of 36 Woodquacket Lane. Okay, this is the property line. That's my house. So the picture you had there, looking out the window from my living room, that was a picture of the balloon that day. You can see how close it is. When you look at it like this, it looks like these are huge lots. They're not. This is only 136 feet wide here.
Route 28 here.
Yes, right, okay. So with the fall zone, if it's 30, if it's 60, if it's 70 feet to the line, it's 110 feet high. It's going to fall into my front yard. Okay? So I was kind of surprised that there wasn't any information about the distance between the base of the tower and my home. I'm very close to this, as you can see. I'm sorry, I don't have something we can put up on the screen. I would really like to ask for a continuance so that I can prepare a better presentation with legal representation. Because when I read the committee's hearing report back in November, they waived the fall rule. What do you call it? The fall what? Fall down rule?
Fall zone.
Fall zone? They waived it. Am I correct?
To a portion of the property, not yours. Is it okay if I...
Is it my property?
Finish his public comment,
All right,
and then
thank
we'll let you respond.
Yeah. So, I mean, maybe I'm just going on what I've been able to read and understand in a limited amount of time here. But that's my concern. I can say, as far as the realtor's presentation, if I had come in and seen the property, I love the house. It comes with just shy of an acre of land. It's beautiful. It's paradise. It was until 5 days ago. And I can tell you now, if I came in and it had a 110-foot cell tower, I would have gone out the driveway without talking to the lady. Nobody is going to want to have this. You're going to walk out your house every morning and say hello to a cell phone tower, 110 feet tall. It's 35 yards away from you, in clear view of my front yard. Yes.
The Commission said that the proposed tower meets the requirement. Excuse me. It says, quote, "The fall zone requirement is for a distance equal to the height of the proposed tower to any abutting property line."
Right.
Okay? The proposed tower meets this requirement from the residential parcels at the rear of the site.
I read that, and I just was wondering, what did you measure it with? Where was it measured from? Because looking at the property, and as I say, if it's left, if it's left to you folks to decide this type of thing, come out and look at it. I'm not that far away. I'm 10 minutes up the road, right behind the CVS. Drive down my driveway. It's a private driveway. That long, slim line you see there, that is the driveway into 38 Waquaga. Just take a look at it before you decide that how close is close enough? How close is too close? Nobody's going to want to live that close to a cell tower that I know. If this goes through, I'm looking at selling the property at a big loss. I wanted to live there the rest of my life. But I'm not going to have family and young kids come and spend time there that close to something I don't know that much about other than what I read, and it concerns me. I have a lot of concerns about this. I have concerns that they waived a fall zone rule when 40 feet of that thing could fall over my property line, where my house is. Anyway, that's all I got. I would like to ask if you could give me a continuance on this so I could get legal representation. I called Michael Gill, who did the closing of my house back in June. I haven't had a call back from him. I just want to make sure that I'm going to handle this well and properly for you all.
Thank you for your comments.
Thank you very much.
All right. Do you want to respond?
I do. So, first of all, we're all about public input. We've been nothing but transparent, notwithstanding some of the comments. So let me put the pin in the balloon right away here and say we're not opposed to a continuance to let the gentleman read through our materials. We became aware that there was an address issue through no fault of ours, through no fault of the town, no doubt. But the law requires that the abutters list be certified. It was. Notice was sent to the abutters, so legally we've conformed. And, he showed up to the hearing. So there is no prejudice to the abutter, but we understand you get notice of a application that's maybe a couple hundred pages long. He deserves an opportunity to look at it. So right out of the box, we are amenable to a continuance. You may have been going that direction anyway, but I do want to offer that up front. Let him review it. Let him look at his rights, his concerns. But there are some factual issues we need to deal with. I put up on the screen sheet A2, and I would refer Mr. Harrigan to all of the materials that we submitted. They're all online. If you click on the agenda, you can see all of this stuff, and you can zoom in. The 110-foot fall zone is 110 foot from his property line. There's no waiver, as Member Pennard mentioned, the Cape Cod Commission waived the fall zone to the commercial property because we could keep it away from the residential properties and it made sense. And that's what the Cape Cod Commission's allowed to do. If it's a better design, they can waive it. But they didn't waive it for Mr. Pennard's property or any of the residential properties to the north. That's why you'll see the tower is off-centered, as I mentioned. You'll see the dotted radius of 110 feet, which hits his property line. His property is called out on the plans. It's 178 feet from the tower. So not only is the fall zone as required or as proposed or suggested by the Cape Cod Commission, we're actually 178 feet from his property. So
Sorry, just want to clarify for the record. It's 110 feet to the property, 178
Can you turn your
feet.
microphone on?
Sorry, it's 110 feet to the property line, just so we're clear. It's 178 feet to the dwelling, approximately.
correct, from his residence. So the fall zone's from property line. There's no waiver in his direction. There is a waiver to the south and southeast where the CVS is located because it's all a retention pond for drainage for the sites. So there was no harm in moving the tower closer to the commercial site where the CVS is located because it maintained the 110. That's exactly why we didn't center it, and that's exactly why the Cape Cod Commission agreed with us. We'll waive it to the south and southeast if you maintain 110 to the residential area, which is what we did. I do want to make one comment about the timing of the balloon test. We didn't set it. This was something that was done, it wasn't a week before, it was 8 days before the holidays. That was determined with the Cape Cod Commission and the town. There's nothing nefarious there. Nobody did anything to say, well, let's do it at Christmas so people don't see it. As a matter of fact, based on Crown Castle's preference to be transparent, we sent notices to the abutters. We didn't have to. The Cape Cod Commission only requires that it be published. And we said, we want to go a step further. We want everybody to look. We want everybody to see it. And if they want to take pictures, as Ms. Goodwin did, they should, because we're only allowed on public ways. So the views that you see are from Route 28, they're from other public ways or other public properties that the town asked us to get photos from. So there's nothing, I don't want to leave this board with the idea that this was being done in the dark of night. It's been going on for a year and a half. It's been full disclosure. Abutters have been notified. We understand the short timing notice from Mr. Harrigan, and we're willing to give him additional time if the board so sees fit to allow him to review the application and come back. And with that, I'll close my remarks.
Thank you. So yeah, just for the record, we did receive between IT and, or Anna, maybe you can summarize a little bit, but between IT and some GIS mapping issues with the transfer of ownership, the abutters notification, the certified abutters notification did not update to Mr. Harrigan's address, so he did not receive abutters notices when everyone else did. But Anna did, thanks to Ms. Goodwin, it did get communicated, but it was a little bit shorter time frame than what's accustomed. So what are you guys feeling? Do you want to grant a continuance? What's the board feeling here to give Mr. Harrigan an opportunity to?
I'd be happy to.
If the applicant's not, it's not going to put this out, 2 years and the other tower's gone and whatnot, right?
Well, I don't know how often, do you meet every 2 weeks or every?
Yeah, our next meeting would be February 22nd, yeah, or March 8th. Well, luckily Denise has been here tonight.
March
That's
8th?
online.
I guess it's
That's
up
going
to,
to be Zoom-based, right, Anna? Yeah, both March meetings are Zoom.
is it?
So
worth
March
asking?
8th is available? I just need to check.
8th, yeah, February 22nd or March 8th, and that would be on Zoom.
I have a question.
Yeah, go ahead.
Yeah, how accurate is the location of that crane? Like the pictures they have, did you see their pictures, by the way?
I did not, she brought them to you. Thanks. Okay.
If we're talking continuance, Ms. Harrigan, Mr. Harrigan, Ms. Goodwin, is that acceptable timeline for you guys to have time, do you think? To March 8th? It's about a month out.
Oh, that's right.
Okay, I just want to make sure you had enough time to meet with attorney or whatever. Okay. So is March 8th?
I missed that part of the conversation. What was it again?
Oh, I was just asking if that was sufficient time for him as well to
March
push out
8th?
to March 8th, yes. March 8th work for you?
It does.
Okay. So I'll make a motion to continue appeal number
Could I, before we close, could I just respond? So the crane itself, the balloon,
Yeah, the photograph they
is
have.
typically where the tower will be. So
Okay.
it's going to be skewered, but they boom it over. Scott didn't do the balloon test in this instance, but it should be over the tower site as close as they can get. It's going to be
Yeah,
close.
basically, the top of the crane is where the top of the tower is going to be?
Correct.
If we do, just so we're clear, like if we either do a balloon test where we fly a balloon off of like strong string, basically, and we can get it right at the tower location. The problem with doing that down the Cape is wind. So it ends up blowing it out of position. So the Cape Cod Commission requires that we use a crane. The problem with that is at the same time, we can't clear land for the site without having approval. So we have to get the crane as close as humanly possible, and then we boom over to get it as close as humanly possible to the tower center. So that's why the crane's kind of on an angle, if you will, and not just straight up. That's the reasoning behind that.
But the location of the balloon itself basically would be at the top of the tower.
Yes.
And then you're probably the one to ask about siting of it. So you're exactly 110 feet from their
Absolutely.
property
So
line?
Advanced Engineering Group did a boundary survey of the property, so we determined this property lines based upon all record plans available at the Registry of Deeds and the title research that was done by our clients. And then we actually cited it, if you recall on the plans, we're actually at Rev 11. So we did 11 different modifications of this plan. We've been working with the Cape Cod Commission dramatically to do this. As was mentioned previously, the original site was actually closer to the property lines to the north. As part of our working with the Cape Cod Commission, we actually shifted it further away from that property to make sure that we did in fact maintain that 110-foot fall zone to his property specifically. That's something that they, basically mandated, and we were able to accommodate, luckily, for all parties.
Yeah, because it looks like the radius there goes, it just touches 1050 Falmouth Road. Just goes over it a little bit.
And-
Now, is that part of
No,
your-
it doesn't go over it. If you look at the survey, it's meant to be exactly 150 feet perpendicular to the line. So it's
Oh, the
basically
office
like,
building that's there.
oh, from the office building?
Yeah, it goes over that a little bit.
On our subject lot.
Yeah.
Yes, and that's allowed because it's where the property owners,
That's the
of
wave,
that.
yeah.
Exactly. So, but typically, just so we're clear on how the fall zone works, it's kind of poor nomenclature. It's really just like this radial safety zone that's kind of been around since the 90s. But as a practical matter, towers do not fail at the base, right? They're designed, the foundations just inherently as they're designed are over-designed. So they don't topple like a tree at the base. If they do in fact fail, it's typically at or above the midpoint of the tower. And then once they start to bend, the force that is exerted from the wind or the hurricane is greatly reduced, and it crumples. It does not crumple at the base. It does not fail at the foundation or the anchor bolts. It's specifically designed to fail at the midpoint or above.
Now, if you'd known about the abutter's concern, would you have tried to, can you nudge it towards 28 at all? or-
We already did. That's the thing. We shifted it, I'm guessing, about 40 feet or so from its original implication. So directly adjacent to the southern, I call it Plan South, 28 side, is the drainage swale for that project. Our fence is literally right up against that, and then the tower is actually offset so that we barely have enough room, more or less, to get the foundation, which will be installed below grade, roughly 8 feet below grade, to fit without affecting the drainage swale that's there. But that is, again, it was discussed at great length with the Cape Cod Commission to find a location that worked for that purpose.
All right, so I'm going to make a motion to continue this. For the record, public comment remains open on this, but in appeal number 2023-001 and appeal number 2023-002 to continue to March 8th, 2023.
Time certain.
And at 7 p.m. I need a second.
Second.
All those in favor?
Aye.
Aye.
Opposed? Abstentions? None. So we'll continue this on March 8th.
And that'll be via Zoom, right? You said?
That will be via Zoom, yes.
Is it a hybrid? Can we come in person, or is it only Zoom?
Only Zoom.
Only Zoom?
Yep. All right, and it is after 10 o'clock, but our last item, in appeal number 2023-003, Hillary M. Stone, trustee of the Malpass Trust, has applied for a special permit pursuant to section 240-44A, accessory uses permitted with a special permit. The applicant seeks to construct an accessory structure, boat, barn / garage / greenhouse on a lot immediately opposite and across the road from the lot in which the principal use it serves is located, with both lots being held in identical ownership. The subject property is located at 94 Indian Trail, Barnstable, Massachusetts, as shown on Assessor's Map 336 as parcel 015. It's located in the Residence F1 RF1 zoning district. And Attorney Schultz is not here. We were supposed to make him sit here for 3 hours to ask for this continuance. But we have received an email letter today from him saying that he had a unexpected or had a knee surgery and would like to continue this. He does not have a date requested, but I'm going to assume, do we have space on the 22nd? Yes. Okay. So I'll make a motion to continue appeal number 2023-003 to February 22nd, 2023 at 7 o'clock.
Second.
All those in favor?
Aye.
Aye. Opposed? None. Abstentions? None. Correspondence, I don't think we received anything. Nope. And any matters not reasonably anticipated by tonight? No, none. Upcoming hearings, February 22nd, March 8th, March 22nd, all will be via Zoom. Motion to adjourn. I need a second.
So moved, Paul.
All those in favor?
Aye.
Aye. Opposed? None. Abstentions? None. We are adjourned. We're all.